appeal in the matter of Ivanishvili and Signature Litigation LLP.
Yes, Mr. Williams.
Yes.
We have read the Costs Judge's judgment. We've read the skeleton arguments and we've looked at the authorities. It seems to us that ground one is the key that opens the way to all your other grounds. And we would like to hear you both on ground one before we move on, if we need to the other grounds.
My Lord, thank you for that indication. Thank you. My Lords, if it please you, I appear on behalf of the appellant with my learned friend Mr. MacDonald. My learned friend Mr. Mallory KC appears with Mr. Teasdale for the respondent. My Lords, in June 2016, Lord Sumption gave the opening speech at a conference of the family bar and famously, if undiplomatically, accused them of being too blinkered by their own specialism. The family bar, he said, remains one of the more insular areas of practice. This deprives it of perceptions that would enrich it. There must be a willingness on the part of practitioners to look critically at familiar principles and relate them to what is happening elsewhere. Sometimes distance lends enchantment. And his particular complaint was that over-specialism leads practitioners to take for granted rules of law which strike outsiders as distinctly odd, but are too familiar to have struck them that way. And now, of course, the present case concerns not family law, but the law relating to solicitors' bills of costs. So in insular terms, we're moving from Australia to Rockall. But with respect to the cost judge below and my learned friends, we say the vice that Lord Sumption identified is very real in the present case. Cost judges have become inured to highly technical arguments about what constitutes a solicitor's bill, which have become untethered from what we say are the straightforward requirements of the controlling statute, and the small number, essentially a quartet, of respectfully clear and pragmatic decisions on the question from this court. And the result has been a surge in the number of disputes on this issue. And the court might have noted that even though the authority bundle goes back nearly a century and a half to 1878, and even though the controlling statute goes back half a century to 1974, well over half the cases in the bundle were decided in the last 12 years, with much uncertainty and expense resulting. And if we'd added decisions of the cost judges of the first instance, we would have had multiple volumes. And as the court would have seen, the particular issue, and this is really underpins ground one, has arisen in connection with the partial or discounted CFA arrangements, which are now so central to much commercial and indeed CAT litigation, under which, if the respondent is right, solicitors cannot submit interim bills, and clients may therefore be able to reopen paid bills, not just paid bills, but bills paid without complaint many years in arrears, in a manner which risks chilling the use of such arrangements, despite their great utility to solicitors and clients alike.
Mr. Williams, the word missing from that is statute bills.
Yes.
Not interim bills. Solicitors can render interim bills as much or as rarely as they want.
Well, they can ask for payments on account. Yeah, I mean, that's the dichotomy.
Interim statute bills.
Yes, indeed.
With all the restrictions that the statute brings.
Well, we'll see what those restrictions are. We say they're actually very limited indeed.
But that's what we need to focus on.
Indeed, and with respect, that's an entirely fair intervention, my lord, yes. The issue, however, about the extent to which one can submit interim statutory bills in the course of a discounted CFA arrangement is one that is important to the market, and not just, as my learned friend's skeleton perhaps implies, important to Signature. Not least because one of the reasons discounted CFAs have become very common is that they tend to operate in conjunction with litigation funding agreements, which again, as the court will know, have become very prevalent in recent years. And the way it works is essentially the funder will pay part of the solicitor's fees as the case goes on, enabling the solicitor at least to cover their overheads and office costs, even if perhaps not at that stage to make much of a profit. With a balance being payable in the event of success. And so essentially discounted CFAs have proliferated in foot with litigation funding agreements. And I think my Lord Justice Lewison, in giving leave to appeal in a previous case, recognised that this was an issue of some importance in the market. That's the Spray case, which the cost judge refers to. And I in fact see that my Lord's order has found its way into the bundle, but I think that's probably an artefact of when we were trying to persuade the court this merited a leapfrog appeal, rather than in any sense we're attempting to say that your lordship decided anything by giving leave to appeal. Obviously, you merely decided the point was argued.
Part of the problem is that the statute hasn't been amended to take account of new funding arrangements.
Indeed.
It's in the same form as it has been for 100 more than 100
Well,
years.
there's
I mean, I
certainly-
suspect this whole principle that the cost judges relied on probably originates in Georgian time.
I think the first act, which certainly clear vestiges of it can be seen in the modern act. If 1974 is modern, I'd like to think it is just about. And it goes back to the reign of George II. And very large chunks of the current act are just a modernisation of language from the 1843 update, which was early in the reign of Queen Victoria.
Yeah.
I think the second or third year of her reign. So what your lordship says is quite right. And even looking at the papers for this case, there's a quotation from an edition of Cordery in 1999, which says, "Oh, interim statute bills are very rare." And I have to say, I very much doubt that was correct in 1999. I suspect that was an artefact of an earlier edition. But certainly, as of 2024, obviously interim statute bills have become extremely common. It would be almost a subject for a Bateman cartoon, the solicitor, at least in commercial practice, that didn't submit a bill before the end of the business. So I'll summarise the course my submissions will take in a moment, and obviously I need to tailor them somewhat given the indication from the bench at the beginning. But right at the outset, and as an opening reality check, I wanted, if I might, to take you to one of the disputed invoices, because we say they are instructive. And they're all in similar form. So just to ensure there's no suggestion of cherry picking, I was just going to take the first, which is in the supplemental bundle, tab 6, page 180.
180.
My lord, yes. So obviously it's a document in the livery of Signature Litigation. It's described as an invoice with an invoice number in the top left-hand side. Immediately beneath that, it has a date and tax point. It covers a distinct period. It's not quite it's not an exact month because, of course, it's the first period of billing, but thereafter most of the invoices are monthly. 11th of January 2016 to the 29th of February 2016. Has a VAT number and it provides for VAT, though in fact VAT isn't chargeable because it's a supply to a client outside the European Union. A detailed narrative is attached to it. We haven't got that in the bundle. We've got an example because it would be too long, but we've got an example of one of the narratives, and essentially you'll see from that example which one has, I think it's 331 through to 346. These bills are served with essentially timesheets of the breaking down what's done by fee earner.
Yeah.
I'm not obviously going to go through any of the detail of that. Obviously, the bill itself is in an exact sum to 2 decimal places. It's signed by signature, which, as we'll see, the Act requires. It's clearly a demand for payment because it says payment terms, please pay within 14 days. And it gives details of Signature's bank account. And in the bottom, in very small print, it provides for interest for late payments, and it says that the client may have a right to assessment. And the reason why the word "may" is used is simply because you don't always have a right to assessment. It depends on, for example, if a solicitor is remunerated by a fixed fee, which has been agreed in writing, there isn't a right to assessment of that because of the restrictions on assessment, where you have what's called a contentious business agreement. So that's why it says you may have a right to assessment. It depends on the nature of the charges. And this is the first of a sequence of invoices, all in the same form. Over the page, at page 181, you'll see there is a sub breakdown of the work done by fee earner with their hourly rates at the standard rate, their time spent, the value of their work at the full rate, and then the discount rate, which at this stage is being billed, which leads to a grand total in the exact sum. And if one looks at the following sequence of invoices, but I'm not proposing to go through them in any detail, or indeed any detail at all, you'll see that each of them is self-contained. There's no suggestion that there is any sort of running account where balances are carried forward from one invoice to another, against which payments on account are being debited or credited. And as we'll see in the case law, it's the existence of a running account which has often been led to an apparent bill, in fact, being found not to be a statutory bill. And so that's what we're dealing with. And I say really with no intention of flippancy, although I appreciate it might sound like a flippant remark, but it's my submission that literally no one in the world could look at that and say that is not a bill, except for a specialist legal cost practitioner. It is self-evidently a bill. And whatever one thinks, if I can go back to
if the principle is that once you have sent in your interim statutory bill, you cannot require an increase in the fees charged, then if you are right in saying this was an interim statutory bill, you are not entitled to the success fee, are you?
Well, obviously that's what I need to come to, but I say that I am, because I say that is a different charge for a different thing that arises on a different occasion, and it is no different to the case this court looked at, for example, in a case my Lord Justice Coulson sat on called Boudier and Slade, where a subsequent bill was submitted for the same period of work, but it related to disbursements which had been passed on to the solicitor in arrears, and this court said, well, there's no difficulty with that because for finality, you look at the subject matter of the bill. You don't just blindly look at the period. But it's obviously a point I'm going to need to develop. And
quite. I mean, if a judge in some far-flung jurisdiction decides in favour of the client, what additional work have you done for this over this period?
Well, we haven't done any additional work. What you have is a reward payment because the client has negotiated an incentive to, if you'll forgive the crudity, which is always trotted out in these cases, to put the solicitor's skin in the game, and that is triggered because of a subsequent contingency which eventuates. So it is not a bill for the same work. It is a new liability which has arisen because of a subsequent event.
But I mean, do you accept that in order to be a statutory bill, the bill delivered to the client must be complete and self-contained for the work that it covers?
In relation to its subject matter, yes. Although I would say that whether or not a bill is complete or self-contained, there's a risk of circularity. But in the old cases, that isn't in fact a characteristic of the bill; it's a consequence of the bill. The bill is final because it's a statutory bill.
Well, that's why I asked you about your contingency fee. If it is a final bill.
If it is a final bill, and if the classification of the successee was for the same work, it was for the same subject matter, then it's subject to the point that it may simply require a revised approach in circumstances where none of the decided cases are contemplating discounted CFA arrangements. They just didn't exist at the time any of them were decided. Subject to that, there would be then obviously my learned friends and the cost judge their case would be vindicated. But I would say that one has to be wary, and I know this is a mantra the court will often hear about treating previous decisions like statutes. But obviously none of those previous decisions talking about final and self-contained bills are talking about that in the context of a success fee or whatever it may being triggered long in arrears of the work itself because of an outside event eventuating. So they simply haven't had to grasp at that, and so it would be my case that even if I'm wrong in my sort of categorization of the incentive payments, the contingent payments that come later, and they are prima facie objectionable to a principle of self-containment and finality, I would say yes, but those are principles which have been established in cases where that sort of retainer didn't exist. In fact, in the vast majority of those cases, any such a retainer would then have been unlawful. And it is open to this court to say, well, these principles of finality and such like as they've been expressed in previous cases, they have to, those cases didn't decide the issue and they have to yield to commercial reality. And to some extent, that's what happened in Boudier. In Boudier, all those cases, Davidson's and Fenley, Barry and Rosen, which we're going to come to, some of them, were sort of trotted out to the Court of Appeal. They had persuaded the cost judge at first instance, they persuaded Mrs. Justice Lang at second instance, and the Court of Appeal just said, yes, but they weren't dealing with this question. Those remarks about finality and self-containment were not made in the context of the point which we have to decide. Sorry if that's a slightly longer answer than your lordship would have liked. So, but if I just go back to my exposition of that bill and my remark, as I said, without intended flippancy, that really no layperson or indeed non-specialist lawyer would look at that and say, oh, that's not a bill. I do say that whatever one, going back to my opening, my opening flourish, whatever one thinks of Lord Sumption's qualities as a diplomat, we do say this is a paradigm of the phenomenon which he was there describing. Lawyers being so hedged around, specialist lawyers being so hedged around with what Lord Sumption described as the vernacular of practice in their area, that they have become blind to what he called distinctly odd outcomes, the distinctly odd outcome of finding that is not in fact a bill within the meaning of the Solicitors Act. And our case is that each of the invoices submitted by Signature was self-evidently a bill for its charges, not a request simply for money to be paid on account, to be held as security inter alia for future bills. And we would venture that in ordinary circumstances, no one would be more indignant than Mr. Ivanishvili himself, if he were to be told come 2030 or whenever these cases in Bermuda and Singapore and such like finally conclude, that at that stage Signature can, if they so choose, reopen all these invoices that we have from 2016, 2017, 2018 through to 2022 and revise them because they aren't in fact final. And indeed, if I may respectfully say so, you'll have seen that the cost judge at various junctures says, oh, I think very clear words would have been needed to attain that outcome. I would respectfully turn that on its head. I would submit that what you would require very clear words for would be to say that this invoice and the whole chapter, the whole book of invoices like it, is an invoice which is capable of being reopened by the solicitor 15 years in arrears, because it was just an application for payment on account, in no sense final, subject to revisitation and increase. In my respectful submission, that's the proposition that would require very clear words. And in fact, that is the proposition that would be more damaging to the interests of the typical client. So I haven't quite worked out yet. I'll obviously think on my feet how I'm going to revise my presentation to take account of the court's opening indication. But subject to some footwork around that, what I'm going to do is firstly review the statutory requirements, which my Lord Justice Coulson referred to a few moments ago. Secondly, review what I've called the quartet of decisions in this court. And third, go to the terms in this case. And fourth, to say what we say respectfully are the errors in the cost judge's conclusion. And fifth, as an adjunct to that, consider the two High Court decisions that are prayed in aid against me, which are Barry and Rosen, and then the Spray and Rawlinson case, which is the one case that does address a discounted CFA arrangement. So far as the statutory requirements are concerned, they're very few. We have the Act in tab 1 of the authorities bundle. So the first extracts, this is the whole of part 3 of the Act, which deals with remuneration. I think we can skip through to section 64, which begins at page, is on page 14. I think if any of your lordships are using the electric bundle, the page numbering is the same, happily. Firstly, in contentious business, section 64, at the option of the solicitor, a bill can simply be in a gross sum, or it may be a detailed bill. So that is the first indication we would say that the statutory formalities are pretty light touch. The solicitor can just serve a gross sum bill, albeit then the client has a time within a prescribed time limit to ask for a detailed bill to be substituted. So that's section 64. I'm going to come back to section 65, which deals with payments on account. But section 67, opposite page 15, next page, that deals with the treatment of disbursements, and simply says that you can include disbursements even if they haven't been paid, in essence, but they have to be paid by the time the assessment is complete. 68, we don't need to dwell on that. That gives the power to order a solicitor to deliver a bill. 69 is where the statutory formalities lie. So the first point is and again, one of the characteristics of a bill, only a bill can be sued on. You can't sue on a payment on account. It's a point the cost judge makes. No action shall be brought to recover any costs due to a solicitor before the expiration of 1 month from the date on which a bill of those costs is delivered. So only a statutory bill can be sued upon. There are then special rules if there is some concern that the client might be, in crude terms, about to abscond, do a runner, whatever one might say. Can I just say, before I come on to the rest of the statutory formalities, that this point that you can only sue on a statute bill is potentially important, because firstly, as we will see, because of that, the courts have therefore identified the question of whether an invoice on its face is demanding payment as important in determining whether it's in fact a statutory bill. And so in some of the cases where it's been held that what was arguably a bill was in fact just a payment on account, the courts have said, well, that's because there's not a demand for payment. And in our case, I've just shown you the invoice we submit that they are manifestly demands for payment. So secondly, and as we argue in our skeleton, the fact that solicitors can only sue if a statutory bill is delivered is, we would respectfully submit, a reason to be somewhat circumspect in adding to the statutory requirements for such a bill, which as I'll continue to develop, I say, are very straightforward. And thirdly, the fact that solicitors can't sue for their fees absent a statutory bill may, we say, itself be a relevant piece of background context when it comes to both construing their terms of business and classifying either as bills or requests and payments on account the invoices they actually submit. Because it might be thought, when one is looking at matters commercially, to be actively unlikely that a solicitor embarking on a project and anticipated to last in excess of a decade, as in this case, would omit either to provide a right to deliver interim statutory bills that it could sue on, or then having given itself such a right, or having negotiated for itself such a right, then in fact to fail to deliver them and to deliver requests for payments on account instead. So we say that that's 69(1), and the fact that only a bill can be sued upon is an important element to have in mind in the sort of process of taxonomy of any given invoice. Then the other statutory formalities can be seen in subsection 2. The bill has to be signed.
The solicitor embarking on this long-term litigation, who sends in an invoice, to use a neutral word, which is not a statutory bill and which is not paid, will be entitled then to terminate the retainer under section 65 and serve a final bill.
Correct.
So it's not quite so disastrous, is it?
Well, I suppose that is. I mean, that's akin to sort of pressing the sort of big red launch button on your, on your missile, if you terminate the retainer, because you can't agree the amount of a payment on account. But obviously, your lordship's right, and I am going to come back to section 65. So that's again another fair intervention, as one would expect. So I was just coming on to subsection 2. The requirements, the formal requirements are it be signed and it be delivered. Signing is then fleshed out by some amended sections, which have really been amended since Queen Victoria's reign to introduce the concept of e-signatures. Don't need to get into that, and the delivery sections have been amended, again, not something prevalent in the reign of George II, in order to allow for email delivery. But essentially, the bill has to be signed, and it has to be delivered to the business address or whatever it may be of the client. These are pretty straightforward requirements. And as we say in our skeleton, judicially, they've in fact been interpreted in a very liberal way. For example, there's decisions of this court which say it's perfectly fine to rubber stamp a signature on a bill or to have a typed signature.
None of this is an issue.
None of this is an issue. And there's no arguments that the bill in this case, the bills in this case, the invoices in this case, complied with the statutory requirements of section 69. And one has at the bottom 69(2)(e), where a bill is proved to have been delivered in compliance with the requirements of this of this part, it's not necessary in the first instance for the solicitor to prove the contents of the bill, and it is presumed unless the contrary is shown to be a bill bona fide complying with this Act. And you may have picked up from the Costs Judge's judgment there was not a profound disagreement between my learned friend and myself below, but a sort of slight difference of emphasis about burdens of proof. And the Costs Judge proceeded on the basis that I argued, which is that once you've proven delivery in accordance with Section 69, then it's for the client to prove that the prima facie bill is not such. But I don't imagine this case is going to turn on the burden of proof. But but the Costs Judge accepted what I said about that, and I don't think there's a respondent's. I don't think the respondent's notice revives the argument to the contrary. I'd be corrected if I'm wrong. So we then have Section 70, which is the right to detailed assessment and the time limits. And obviously the court will be alive to the fact that really what drives this dispute is concerns on both sides about time limits. Because on our side, of course, the concern is, well, a bill which you paid without demur, or indeed months of bills which you paid without demur amounting to millions of pounds in 2016, 2017, 2018, you can't just, in circumstances where you've got relatively strict time limits for detailed assessment, it just makes no sense that you say you could reopen them all potentially, in this case, I think, on the chronology, sort of 14 or 15 years in arrears when the success fee is earned. And obviously, the client has got a different view of it. What I did, however, want to stress is that Section 70 is sometimes approached by litigants and, with respect, cost judges, as if it's the only mechanism by which a client can challenge charges. For example, in one of the decisions in our bundle, cost judge is quoted as suggesting it would be draconian to accept any attenuation of the Section 70 rights resulting from a compression of the timetable. But with a plea for forgiveness, if it's a statement of the obvious, of course, it's not the position that Section 70 is anything like the client's sole remedy. It is a super-added additional right, unique to solicitors' charges, which simply gives the client a remedy on top of all the other remedies that the client allows anyone that wants to challenge a supplier of services. And it's a right that's essentially Section 70 is a codification of the court's supervisory jurisdiction over solicitors as its officers. And that's why there's no equivalent right over, for example, direct access barristers' charges or the fees of legal executives and things like that, because they're not officers of the court, but solicitors are. So again, with apologies for labouring the obvious, clients still have all the usual rights and remedies in the event of alleged overcharging. Firstly, and most obviously, the self-help remedy of just declining to pay, or declining to pay in full, in which case it's absolutely clear that the solicitor must prove their charges. It's not a liquidated demand where you can just get summary judgment. You have to prove the reasonableness of your charges. And indeed, in the King's Bench division, more often than not, if there's a dispute as to solicitor's charges where a bill hasn't been paid, there's a claim on a debt. It's simply referred off to a cost judge for an assessment, precisely because it's not a liquidated demand. So there's the self-help remedy. And obviously all the usual remedies in contract restitution, remedies for breach of fiduciary duty, a claim for an account, recourse to the regulator, and in the case of consumers and small and medium-sized enterprises, the legal ombudsman service. And obviously sophisticated clients like Mr. Ivanishvili with his own battery of specialist advisors can and often do stipulate for any other ADR mechanism which they might wish to, and it's by no means uncommon, for example, in litigation funding contexts, to see a recourse to a KC resolution procedure where a KC is an expert resolves matters. Now, some judges, and my learned friends rely on this, of course, have suggested great prejudice to clients if they must dispute lawyers' charges at an interim stage. But firstly, we say, well, that is not a sound objection to the course that we commend. Firstly, that's inherent in any interim billing process. And as my Lord Justice Lewison put to me just now, with a request for payment on account. And that potentially derails the entire solicitor-client arrangement because the solicitor's only remedy in that course is to terminate the retainer and submit a final bill. So in fact, that is the context where you need recourse to the more nuclear option, if it's not absurd to use a comparative in the context of nuclear options. And it also ignores what other judges have rightly seen as compensating advantages to interim billing. The first is certainty. The bill can't be reopened. And again, you'll have fresh in your memory what I have said, that in ordinary circumstances, you might think it would be Mr. Ivanishvili who would be most indignant at the proposition that Signature can reopen its historical charges, albeit that's where his argument takes him to.
Where does this principle come from? Is it the interpretation of the phrase "a bill of costs"?
Well, it's simply because you essentially have a dichotomy. It's a bill of costs or a payment on account. If it's just a payment on account, then it simply isn't. It's simply writ in water until the bill is delivered.
What I'm putting to you is, I mean, there's nothing in the statute that says you can't reopen a bill.
No, that's essentially.
So this is the judge's interpretation of the phrase "a bill of costs."
Yes.
Is that where the principle comes from?
Yes, there's been a certain amount of glossing, judicial glossing. I've already given the example of the rubber stamp. There's also been some glossing about, we've seen you allowed gross sum bills, but there has been some judicial glossing to say you can't just have two professional charges, you have to give a little bit of narrative. And that was an issue in a case we don't have in the bundle, but it's considered at length in the Boudia case, that principle.
And does this principle predate the 1843 Act?
In our bundle, we have, I can't say that it does. We certainly have Victorian authorities.
Yes.
We have the, I keep forgetting the name of it. It's Thompson, v. Thompson, which is, and what the judges explain in v. Thompson is it is a judge-made rule, in essence, to prevent solicitors putting in inflated bills, and then as soon as their client challenges them, withdrawing it and putting in a lower bill. In the hope that may spare them the 1/5 rule on the costs of what would then have been called a taxation. So it is a sort of judge-made anti-avoidance mechanism in modern terminology. Yes, that's very kind. I'll come to that. So I think before you asked me that question, my lord, I was about to say what I described as compensating advantages for interim billing.
Certainty was the first.
The first one was the certainty. Second, it means that any dispute happens while events are fresh, not years in arrears. And I don't, that may sound like a sort of slightly desperate point, but in my submission, it's not a desperate point, it's a very important practical point. In firms of solicitors, personnel change. And in business cases, it's obviously different if you've got a personal injury case, say, but in business cases, personnel within the client will often be turning over massively over the course of a year, let alone a decade. And so not having stale disputes, in fact, is important. And that might be thought to actually underpin the thinking in Section 70, which does have relatively brisk time limits for this sort of special procedure to be invoked rather than the more cumbersome procedures of suing for breach of contract or issuing an application in the Chancery Division for an account, for example. It also means that any dispute will be localised and manageable. If you have your monthly bill and you object to some particular charges, and in the very unlikely event it doesn't just get negotiated to a conclusion, it means that the dispute will be self-contained in relation to a defined and short period. It doesn't require the termination of the retainer, as with the payment on account, back to my lord's point. Whereas what my learned friend's point takes into is essentially an audit of potentially years or more than a decade of solicitor's work right at the end of the case. So that's the third point. The fourth point, and I appreciate this is less tangible, but we still say it's of great commercial importance. It enables solicitors to offer terms they might otherwise be unwilling or unable to offer. Because if a solicitor is saying, well, if a solicitor is told the cost of offering your client a conditional discounted fee arrangement is that even the unconditional discounted fees which your client has paid without dispute can be reopened years in arrears, and that may mean that a solicitor either won't or can't offer such terms. And as I said, without in any sense praying it in aid as if it was some sort of authority, I think in granting leave to appeal in the Spray case, my Lord Justice Lewison actually commented on the importance of that question to the legal marketplace. It is so it may be untangible, but nevertheless, in our submission, it is an important factor. And of the points I've just given, the first two, certainty and ensuring disputes are conducted while they're fresh. I'm not inviting you to turn it up. But those are points made by Mr. Justice Friedman in the latest of Mr. Richard Slade's seemingly endless disputes about his charges, which one has in the authority bundle, tab 19. And for your Lordship's note, it's paragraph 62 of Mr. Justice Friedman's decision in the Boudia saga.
Boudia 2.
Boudia 2, yes. Surprisingly, the law reporters don't call it that, but Boudia 2. Can I, just before leaving section 70, just again, this is not a submission, it's simply for the courts, so the court's aware of it in case it causes puzzlement as you look through the authorities. And some of the cases in the bundle, there are references to the court's inherent power to order an assessment outside of section 70. But the survival of that power was disapproved by the House of Lords in 1990. In a case called Harrison and Chew, which we don't have in the bundle. This is common ground. The House of Lords, in essence, held that Section 70 was a substitution for the common law right to assess solicitors' bills, and it was a complete codification of that part of the court's supervisory jurisdiction. So there isn't an inherent jurisdiction outside the statutory jurisdiction. So references to that in some of the older cases can be overlooked. And the last point I was going to make about the statute is the one which my Lord Justice Lewison anticipated, which is section 65, back at page 14. That's where the statute recognises this dichotomy between an application for funds, which is not a bill but a request for money on account, which in some of the cases is called a mere request for money on account. And section 65 under the heading security for costs. So traditionally, I think modern commercial practice may have changed somewhat, but traditionally, payments on account, that was money you got to secure your right to future payment, and that was money you just held on your client's account. It was client money, not office money in the traditional terminology. So it's something that was paid as a security. And in contentious business, you can ask for a reasonable payment on account. And if there's a failure to do that, as my Lord said, you can give notice and withdraw from the retainer, and at that point submit the final bill. There's an overview of the differences between a bill and a request for money on account in Friston's textbook, Friston on Costs, which is at tab 3. And I was just going to take you to page 32. But I think it really just summarises what we've been looking at. It's between 3506 and 3510. So he says ISBs must be sorry, page 32, my Lord.
Yeah.
So
paragraphs 3506 through to
3510. So all on page 32 of the bundle.
Okay. Yeah.
Could I just pause, because it won't take.
Yeah.
Can I go back to something you said about money paid under section 65(2) traditionally being regarded as security? And then you made a point about it being held on client account, not office account. There are rules, are there not?
There are.
Account rules as to when you can take money off client account and transfer it to office account.
There are. We were actually had this discussion, Mr. McDonald and I had this discussion yesterday as to whether it would be helpful to put them into the bundle or whether it's just overly technical. But certainly those rules do say at one point that payments on account is client money. But then they do give a procedure whereby you can make something office money, although that term is no longer used in the most recent rules, by either raising a bill or another written notification to the client.
That's what I was asking. You don't need to have a statute bill in order to take money off client account and transfer it so it becomes the solicitor's own money.
Well, you certainly don't need to have, it certainly appears that the solicitor is allowed to transfer the money to their office to account if they give a written notification. But the rules still say money paid on account is client money until a bill is delivered. So the reality is that the SRA's drafting is not completely clear on the issue. Ultimately, the reason we haven't put them into the bundle is because their ultimate status of law doesn't depend on what the SRA says, because the SRA may itself be mistaken about what the law is. But certainly the rules begin with a statement, it's client money until you put a bill in, but then they have that provision which your lordship's just identified.
Well, you're obviously right that what the SRA say can't change the meaning of the statute, but I'm not now sure whether your submission is that if you ask for money under section 65(2), it's not the solicitor's money, it's only the client's money, and that might help on the construction of the statute.
Yes.
So what is your submission?
My submission is that it is client money, because we'll better put the account rules in, but that's A, what the account rules say, and B, that's consistent with the statute with the structure of the Act itself, which says which heads this section about the right to ask for money on account, that it's headed security. It's a security. It isn't characterised as more than that. And it's also consistent with the principle in the authorities that a request for a payment on account is not a demand for payment. Now, what does that mean? Because it obviously is a demand for payment. If you say to your client, I want money on account, you're obviously asking your client to pay you money on account. So when the authorities say it's not a demand for payment, one way of explaining what otherwise seems rather confusing is, well, it's not a demand for payment in the sense that the money once paid will belong to the solicitor, rather than merely being money belonging to the client that is in the solicitor's custody.
One is reminded of Lord Sumption's words.
Yes. Well, that's why I thought it might be yes.
It's a demand for payment, but it's the client's money. So I'd like you to pay, but it's your money.
Well, I suppose the holding for example, paying something into a client account or into an escrow account is not a particularly unusual commercial arrangement to have security whereby it doesn't become the counterparty's money, but it does become a fund which the counterparty can rely on as a security. So obviously, I'm not retreating from the point about this area may have become overcomplicated and overly technical, but what we're here debating isn't that unusual. But in any event, I mean, that is the difference. There is a difference between.
I mean, if it was the client's money, then which the solicitor is holding as a fiduciary for the client in some way, that would bring in all the equitable rules about tracing and goodness knows what. It seems very unlikely that that's what the statute means, doesn't it?
Well, I mean, obviously, the statute as we've seen deals with this in an extremely compressed way, and it just says you can ask for payment on account and it's under the heading security. And then the SRA rules, as I say, they do say that payments on account of costs prior to the delivery of a bill they describe as, they said it's client money. I mean, that's what the SRA account rules say. I mean, it's not.
But they also say, you tell us, that the solicitor can transfer it to office account on delivery of a written notification.
Yes.
Which clearly is something different from the delivery of a statute bill.
I mean, there's a nuance even there, actually, but I think perhaps one can't get into nuances until we've actually got these rules.
But this submission of yours has a very significant practical consequence. If you're right about that, but your ground one fails, it means that all the money that Mr. I can't pronounce his name, Ivanishvili, has paid Signature for the last N years is still his money, because he still hasn't had a statute bill if the appeal is dismissed on ground one, and he won't until the final resolution of all his global litigation. But it's only at that point that you become entitled to serve a final bill, which means that all the money that he's paid in the meantime has still been his money, and if you've helped yourself to it, you shouldn't have done. Is that the consequence of your submission?
Well, as I say, I'm slightly nervous about debating this when we don't actually have the solicitors' account rules in front of us. But I mean the answer is that, as we have heard, that once you serve a written notification, they say you can transfer the money to a different account. But they also do, as I say, specifically say a payment on account absent a bill of cost is client money. So there seems to be some confusion in the account rules themselves. For my purposes, obviously, what I want to focus on is the particular nature of the demand in this case, whether it is classified as a request, at least in the first instance, for a sum to be lodged by way of security with the solicitor, or is it clearly a demand for something to be paid to the solicitor for their use? And naturally, I say it's the latter. But your lordship is obviously right to say that. Depending on how the solicitor's account rules are interpreted, you certainly could arrive at the conclusion which you put to me. But I don't think I need to. I don't need to submit that is. I don't think it's part of my case in such a way that my case fails. If that is not the point that you arrive at, because what I'm actually trying to do here is just contrast a sort of basic taxonomic level, the difference between that which you label a bill which is a demand for payment to you, and that which you label as a mere request for money on account.
Yes, but I think it. I think it may be, I'm not saying it is, but it may be relevant to our understanding of the distinction that the Act draws between a statute bill, or what it just calls a bill of costs, and a reasonable sum paid on account of costs incurred, whether the latter is payment to the solicitor as the solicitor's money, or in circumstances in which the solicitor can easily make it his money, or whether the true position is that until a final bill statute bill has been delivered, the money has to sit in the client account, because then the consequences of whether what the solicitor has delivered is under Section 65 or under Section 69 become much more stark. Have I misunderstood that?
No. I mean, as I say, it's not a point that I've reflected on in exhaustively, precisely because I haven't sought to put my eggs in the basket of saying that a payment on account is always and for all time something which must sit on client's account. I'm simply saying that is. I mean, but that is what it is on any view. That's what it is in the first instance, because the statute provision says this is deals with it as a payment that is lodged by way of security, and I've said unquestionably what the solicitor's account rules do say is that a payment on account of costs absent a bill is client money. I haven't sought to take issue with the proposition that thereafter, if you then do a new act of putting in a bill or something equivalent to a bill, which is a written notification, you can then transfer it to your office account. But I mean, in a sense, that isn't what has happened here. What we have is I have no doubt, is the money has just gone straight into office account because of what was understood was being submitted was a bill. We obviously don't have any evidence about what actually happened to the money.
No. Okay, thank you.
So we'll obviously.
Can we just
Yes.
as we've paused? Isn't all of this just a further example of the difficulty of the Act being 50 years old and wholly unsuited to modern methods of business? Because when the Act was passed, it was common to regard solicitors' retainers as an entire agreement, and that the solicitor put in a bill at the end. And so, to cover the potential risk to the solicitor, there was the security for cost provision at Section 65.
Well, I think
So interim statute bills were rare. Then by about 1980, people are beginning to realise that actually in some work you did need that. Hence, is it Lord Justice Simon Brown saying now
Yes,
people,
that's the Ivanishvili case.
yes,
Yes.
people are beginning to do it.
Slightly later.
So on my reading of it, 65 was designed to try and provide some security for a solicitor who's otherwise on an entire contract and would be providing his bill at the end.
Well, with respect, I think that is absolutely spot on, and the you know, if in metaphorical terms, you know, if you try to use the Solicitors Act to regulate modern commercial practice, you can hear the sort of machinery grinding, because it just hasn't been modernised. And I think there are at least two judgments, I think maybe three judgments now of the Master of the Rolls, in which he has emphasised the urgent need for this legislation to be modernised, because of course it's a vanished world of handshakes and solicitors not even having any written terms, let alone written terms as to the correct statutory classification of any request for payment that they might make before the end of the case. And I'm sure your Lordship is quite right that in 1974, holding money on client account until the end of the case probably would have been the way that it was done. So in any event, we have this dichotomy between payments on accountants and statutory bills, which may or may not be interim. How do you distinguish between them? And we say that really the answer lies in the quartet of decisions from this court, of which the first is Roma and Haslam, which is at tab 6, beginning at page 61. So that's a decision from 1893. And what Roma and Haslam shows is that there are really two key questions, but they're not distinct, or they may not be distinct. The first question is, does the solicitor have the right to submit interim statutory bills? And that's a legal question. And then, if so, has the solicitor done so, which is, on the face of it, a separate factual question. But the reason they overlap, of course, is because of this, what I've called, I don't think it's a term that's used in the authorities a great deal, but what Mr. MacDonald and I have called acquiescence, the fact that a right to submit statutory bills can arise from acquiescence, which is where there is no express agreement, either prospective or ex post facto, but you simply look at what the solicitor has submitted, conclude, oh, it's obviously a statutory bill, look at the fact the client's paid it, and from that you infer that there is an agreement by conduct that the solicitor can submit statutory bills. And that's why the two questions overlap, because sometimes in order to answer the legal question, if there aren't express terms, you actually need to answer the factual question first and then answer the legal question in light of that. So it's a sort of slightly unhelpful intersection between what would be neater as two distinct questions. But in terms of the origin or provenance of the questions, you have those in the judgment of Lord Isha, Master of the Rolls, in this case. And he poses the legal question at 68, page 68 of the, I'll use the bundle numbering rather than the split numbering. In the second paragraph on that page, he says that in cases where several accounts have been delivered, 2 points may be and generally are raised, one of law, one of fact. If the solicitor insists that one of these accounts was a final bill of cost, the question of law arises whether at the time when he assumes so to deliver it, it could be delivered as a final bill. So that's the factual question, as the legal question, I'm sorry. And then the factual question is posed at page 69. And what happens on page 69 is the learned judge finds that there wasn't, in fact, a right to send in the first bill. This is a case where there were 4 bills. But then he goes, so in the light of that, his lordship goes on to consider the other 3 bills, and he says, well, there may have actually been a right to send in those. So he assumes that's the position, I think, without deciding it. But then his lordship goes on, and it's the centre of the page, just below the halfway mark, a sentence that begins, but a solicitor cannot be said. But a solicitor cannot be said to have sent in a final bill if he sent in something which neither party understood nor intended to be final, whether in the case of a series of bills, each bill has been sent in as a final bill, or whether they are mere statements of account showing how far the expenses have gone up to the time of sending them in, is a question of fact to be determined on the evidence in each case. And he goes on to say that therefore it's not something which can be controlled by precedent. Then in the next paragraph he says, or repeats, it becomes therefore a question of fact in the present case whether the solicitor has ever sent in a final bill before the last one. And to determine this, all the circumstances must be looked at. The first bill was sent in when they had no right to send it in as a final bill, so we're bound to draw the inference that the solicitors did not intend it to be what it could not legally be, but that they intended it to be merely a statement of the expenses up to the time it was sent in. I interpose to say that that obviously predates some of the later cases where an acquiescence is found. A great fact in the case for our consideration is the nature of the bills sent in and the way in which they were treated by the parties. So that's in fact where we begin to see, even at this early stage, the possibility of acquiescence.
Just explain, if you can, why the solicitors had no right to send in a final bill for the work they've done in the litigation down to June the 30th, 1890. Why could they not have done that?
Well, because at this stage there was no express right, and so but the courts had developed what's called the natural break doctrine, and I think they concluded that so far as the point of the first bill was concerned, there wasn't a natural break.
Well, the starting point is, as my lord said earlier, that a solicitor's retainer to carry out a piece of litigation was an entire, generally speaking, presumed to be an entire contract.
Well, it was a common law.
Yes, you couldn't therefore claim half the costs for carrying out half the litigation.
Yes, it's Sir George Jessel in the earlier case saying, if someone contracts to take a box of cigars to Birmingham and he throws it out of the carriage halfway, you don't get paid half.
Exactly.
Or you make one shoe out of a pair, you don't get paid 50%. So your lordship's right, subject to the point that in the Chancery division, in equities, then would have been, there was because in the 19th century, Chancery cases was so notoriously long, if I could respectfully say so, a much more forgiving approach was taken in the courts of equity, which you see described in some of these.
Well, that's what Sir George Jessel said in 1878.
Yes.
So that's some years before the case we're now looking at.
Indeed. But so I suspect even in the 19th century it might be going a little far to say that there was a sort of default position in entire contracts. But if it was a relatively straightforward piece of common law litigation, then the position is precisely as my Lord Justice Nugee has just put to me. Yes. But in any event, I think the answer to your lordship's question is that for the first bill, sorry, let me qualify that. But the other qualification to the principle Lord Justice Nugee put to me is that the courts have developed this idea of a natural break, which is if there had been a sort of stage had been reached in litigation, that was a natural time at which the solicitor could do that. And if one just so to answer the
trying to relieve the solicitor of the consequences of an entire contract.
Yes, precisely.
I mean, entirety of construction law is founded
on entire
exactly
contracts.
Exactly the same basis. Interim payments, and then the question of what they cover, what is challengeable, what isn't. So it's just the same.
It is precisely
and the courts develop the natural break as being a way of providing the solicitor with the right to claim some costs if it was, quotes, a natural break.
Precisely, with respect. And indeed the parallel with building cases, in fact, is I think one that I made to the Costs Judge. Because I think there is perhaps a tendency, again, by people who are very specialist, have a very specialist focus on cost cases, to think the entire contract principle is one of these arcane principles which is peculiar to solicitors, but of course it's nothing of the sort. It's a very widespread principle, building contracts, contracts of carriage, all sorts of things. But in the 21st century, and indeed in the 20th century, it's frankly, almost invariably contracted away in anything but the most straightforward commercial arrangement by having a facility for staged payments. And of course, that's what we say we have here.
I think I've answered my question. I think it is what Lord Easter is saying at page 294, 69 of the bundle.
Yes,
is that when the first bill was sent in, there hadn't been
a natural break. Exactly, but for 2, 3, and 4, he assumes that there might have been without deciding it. Thank you, my lord. So yes, back to 295. I was just saying you're beginning to see the acquiescence principle. But I think I got to a great fact in the case, sort of 4 lines down. For our consideration is the nature of the bills and the way they were treated. With each bill, there was sent a statement of account, what was the nature of the statement, an explanation of the bill. Looking at the first bill, we find that though it includes items as to other matters, it begins with the early steps. The second bill carries on, goes on to a particular date, and so with the others. Each bill taking out the transaction for the date when the proceeding ends. Statements of account are sent with the second, third, and fourth bills, in each of which a balance is carried down from one bill to the next, and payments on account made by the solicitor are credited to them. And then he says, now, whether it be in the case of a solicitor's bill or a bill sent in the ordinary course of business, where several accounts are sent in one after the other, in which a balance is carried down from one to the other, every man of business would treat them as intermediate statements, which by carrying on the balance from one to the other, would eventually make up one whole account. There is the strongest evidence in the present case that the intermediate bills were intended to be merely statements of how things were going on and were never intended as, I interpose in square brackets, interim final bills. The solicitors never asked for payment of any of them, but asked for payment on account. They treated the matter otherwise. They never treated the matter otherwise than as one running account. The conclusion I've come to is therefore this: that both sides treated this as one running account, and therefore the point taken that each was a final bill, and that point fails precisely because it's a running account. So those are the qualities in the judgment of Lord Esher, which on the facts leads to his conclusion. And it's similar for Lord Justice Bowen. If I could take that up at page 72. So beginning in the second paragraph of his lordship's judgment, 4 lines down, we have to consider whether the earlier bills of costs sent in were such bills of costs and so delivered as to make them their delivery of bills of costs under what would have then been the 1843 Act. It is clear that they might have been such bills had they been so treated by the parties. Were they divisions or chapters of one bill of costs delivered from time to time, or were the earlier ones delivered as bills of costs within the meaning of the statute? That's a question of fact. To make up one's mind on this part of the case, one has incidentally to consider whether solicitors had a right to deliver bills of costs, and if not, whether the documents were taken by agreement of the parties as separate bills of costs. Sorry, interposed to say here again, one has acquiescence, each standing, if I may so express it, by its own strength. So that's the question that he poses, and then and then he answers the question. He begins to answer it at the bottom of page 73. 3 lines up from the bottom. It must always be a question of fact whether a document is a separate bill of costs or, so to speak, a chapter in a volume. In determining whether a document has been delivered as a bill of costs, it must not be forgotten that the onus of showing it has been lies on the solicitor. As you know, we say that actually isn't right because of the impact of the statutory provision that I showed you, but I don't need to get into that because I don't think either of us are suggesting this case would turn on the burden of proof. But the Lord Justice continues, in this case, this particular case, it is most material to observe that the delivery of bills does not correspond, except perhaps in one case with any natural break. Accompanying each of the bills was a current account showing the state of the cash account between the parties from half year to half year. And finally, and this is a very eloquent fact, there is an absence of all demand for payment of the bills as bills. The solicitors did no more on 2 occasions ask for money on account in respect to the work done by them, extending over a very considerable time. It's true that this fact is not conclusive, but taking all the circumstances together and bearing in mind that the onus is on the solicitors, I think there has been a failure to prove the delivery of separate bills of costs within the meaning of the statute. And lastly, Lord Justice Kay, he also conducts a similar sort of factual consideration of the bills and concludes that they are not statutory bills. And if I can take that up at page 78. Beginning just, I would think, about 8 lines down on the right-hand side of the page, there's a sentence which begins, bills of costs. Bills of costs were, it is true, sent in from time to time, but not with reference to any kind of break in the proceedings. And these bills of costs were accompanied by statements of account, showing the cash received from the clients and the balance due from them. In none of them is there a demand for payment. The true result of what was done is this, that the clients paid money on account to their solicitors, and it was not intended on either side the bills should be the bills of costs required by the Act. but that the intention of both parties was that they should be treated as items in statements of account sent in from time to time, showing what funds the client might reasonably be asked to supply to the solicitors for the purpose of carrying on the proceedings. It was not the intention of either party to interfere with the client's right to tax. So again, it's a process of taxonomy, and really what seems to have done for the solicitors in this case, although the court, even at this early stage, were receptive that a right to submit bills may arise out of acquiescence, or it may be these bills were actually submitted at natural breaks, but they're not bills because they were a running account, not accompanied by any demand for payment. And it's in light of that that the court will understand why I, right at the outset of my submission, showed the court what was delivered in this case, which I was submitted as material of an emphatically different character, manifestly demands for payment, manifestly not any sort of running account, each bill self-contained. And the two subsequent decisions of the Court of Appeal really take precisely the same approach. And that's Davison's and Jones Fenley and the Abidi and Pennington's case. Can I come to those two cases, but I'll deal with them, I hope, more briefly, not least because really these cases are cumulative. So Davison's consists of large quotations from the Roma case, which we won't have to look at again, and then Abidi consists of large quotations from both Davison's and Roma, and obviously we won't need to look at those again. So far as Davison and Jones Fenley is concerned, it's a decision of a two-judge division of this court in 1980, so it's 87 years on. It's another case involving 4 bills. The lower court had in essence taken a Roma and Haslam approach to them, and even though Roma hadn't been cited to the lower court, and found that they were simply a single bill, this court disagreed. As I've said, a large part of Lord Justice Roskill's judgment, it consists of quotations from Roma, which I won't repeat. Okay, I'll have to take it up at page 85. Page 85, there's the quotation from Roma and Haslam ends, and then Lord Justice Roskill resumes. There is now no doubt, I venture to think, what the law is. In a case such as the present, the solicitor is entitled to select a point of time which he regards as an appropriate point of time at which to send in a bill. Therefore, he is entitled to require that bill to be treated as a complete self-contained bill of cost to date. He must make it plain to the client, either expressly or by necessary implication, that is his purpose of sending in that bill for that amount at that time. Then, of course, one looks to see what the client's reaction is. If the client's reaction is to pay the bill in its entirety without demur, it's not difficult to infer an agreement that the bill is to be treated as a complete self-contained bill. And then he moves on to his factual findings in the next paragraph. Applying the principles to the present case, it seems to me that there are within the principles of Roma facts which lead irresistibly to the conclusion that each of the first 3 bills was intended to be and was accepted by the defendant as being, in relation to the period which it covered, a complete self-contained bill in which the appellants expected and intended that the defendant should pay, as in fact he did. And then what his lordship does is he just describes the bills. And he doesn't really spell out what it is about the bills which he is finding is germane. It seems that he just thought it was self-evident. What his account shows is, firstly, the bills were all in precise sums. They credited payments on account and then claimed balances which were paid. You have all this on page 85. The bills were periodic. And they appear to be self-contained. There's no suggestion of there being any sort of running account. And he again repeats, all the payments were made without demur. So they were treated as demands for payment by the parties, again in contrast to the position in Roma. Lord Justice Eveley gives a short concurring judgment, and he also makes the point that a reason for the conclusion in this case was the solicitors hadn't, this is page 87, this is the opening words, the solicitors hadn't been retained for a single action or specific litigation, in which it may be prima facie there's an entire contract and one bill would be contemplated. They were retained generally in relation to the defendant's matrimonial affairs. And as it seemed to me, it cannot possibly be understood by the parties, nor indeed a workable rule, that solicitors should not be paid until the relationship between them had ceased. So with respect, we would say the approach of both Lords Justice has resonance in the present case. So far as Lord Justice Roskell's judgment is concerned, here too we have the regular delivery of what we say are manifestly bills of cost, manifestly demands for payment, not requests for money on account, and no indication of any sort of running account. So all the features that led Lord Justice Roskell seemingly to think it was just self-evident that these were not requests for payments on account, they were bills.
Well, I see the force of that if you're looking at the form of the bill, but you want to charge the success fee.
Well, I appreciate that that is the, I mean, that is, you know,
It's complete and self-contained in the sense that once the time limits have passed, the client can't challenge it and the solicitors can't increase it.
yes. I'm just reminding myself, because I don't want to start sort of addressing you on in points some negligence of your lordship's injunction to start to focus on ground one. You know, obviously, I'm partly showing you this because it's my fallback position that even that in this case a right to bill has come from acquiescence, because what so obviously in our submission self-contained bills of cost which were just paid. It's not actually, the evidence isn't they're paid without demur. The point is the client would sometimes interrogate them and ask for clarification and such like, and then at the end of that process they would be paid. So that's what the evidence was.
But this is ground 4.
But I was going to say,
This is ground 4, and if we were against you on grounds 1 and 3, for example, just by way of example,
yes,
then it's going it a bit, isn't it, to say, well, even if the bills weren't final and complete, and even if the contracts of retainer didn't allow for the provision of interim statute bills, somehow by implication that a result was achieved.
well, what I think is certainly the case. I'm not sure I would assent
You
to
only
the,
get to ground 4 if you're wrong on 1
Yes.
and 1, 2, and 3.
but if I'm wrong on the proposition that it is not a sort of insuperable bar to having an interim statute bill that you can charge a success fee in arrears, then
What none of these cases do, because it wasn't relevant, is to actually look at the retainers.
yeah. Well, I think it's probably the case in none of them really was there a retainer. It was all these cases until Boudia, at the level of this court, are unwritten retainer cases.
So again, one can see why a court might want to find some form of acquiescence, as you put it, for bills that have been paid and passed and so on. But ours is a very different case.
Yes, and I think there's also this. If you're against me on whether or not the reservation of the right to bill an uplift, that in and of itself is so offensive to the principle of finality that you can't have you just can't have an interim statutory bill, then the fact that the client acquiesced in the delivery of what would otherwise have been interim statutory bills for the discounted charges just takes me nowhere.
Quite.
So
I think that's the real point in the case.
yes. Well, and it's certainly the point
Does the
of
reservation of the
margin
right to charge the success fee mean that, however, in whatever form you delivered it, the invoice, again to use a neutral term, cannot be an interim statutory bill,
yes.
because in the event of success, you are able to charge more.
Yes.
That's the point.
That is the. I mean, that's the. So many of the points come back to that. To that, yes. That everything else I accept to some extent footnotes to that central conundrum. So let me therefore, and apologies if I haven't been sufficiently faithful to your lordship's initial injunction so far. Let me therefore, try to focus much more intently on that specific issue. That obviously is the issue of what on the authorities is often called finality, or you might also see they also use the term self-contained, and to some extent those terms are used interchangeably. So what is that? What is that principle? We've obviously just visited Lord Justice Ruskell, who talks about a complete self-contained bill of costs, but obviously in a context where no attention at all needs to be given to the situation in a CFA case, because CFAs are illegal in 1980 and will continue to be until well into the next decade.
Yeah.
The origin then of the point that a case, a bill can't be final if it's open to subsequent variation, which is a point that's relied on against me. I think that, although it's a case mostly about acquiescence, I think that does start in the Abidi case, so we still should visit it. So that's the next divider beginning at page 89. This is Lord
It's in the
Justice.
quotation from Cordery,
It's
isn't
the
it?
quotation from Cordery, precisely.
Just before you go there, as you pointed out, Lord Justice Ruskell in Davidson said, before the solicitor is entitled to treat an invoice as a complete self-contained bill of costs to date. What do you say that principle? I mean, that's clearly a principle that he's laying down, and that he's saying a bill of costs for the purposes of the statute means a complete self-contained bill of costs to date. Well, what is, in your submission, what's the ambit of that principle? Because your bill is plainly not.
Well, I would say it's self-contained in the sense that it is the bill is final in relation to its subject matter. So it is not a bill in the same way. So the dichotomy always to keep in mind in my submission is that throughout this generation of cases, and we're about to see it in the BD, there's just treated as being a simple dichotomy between bills and requests for payments on account. Now, a request for a payment on account is ex hypothesi not something which is self-contained, because it is simply requesting an influx of funds for you to cover ongoing business, which is to be billed in the future, and at that point there will be a reconciliation. But if you are submitting an interim bill, which on the judge-made authority that my Lord Justice Lewison canvassed with me, the judges have said that once you put in your statutory bill, your bill which complies with the Solicitors Act formalities, that is not a bill that can be revisited or reopened without the court's permission. So it's self-contained in that sense. And as I said, there is a sort of chicken and egg point here, because it's not always very clear whether the courts are saying it's a bill because it's final or it's final because it's a bill. I mean, that isn't a point. That's not a point which is there's always a great deal of precision about in the authorities.
They're two sides of the same coin, aren't they?
Well, it's a question of. I'm not sure that's quite right, because is it final because it's a bill, or is it a bill because it's final? I mean, it might be that you put in a bill not wanting it to be final, but the court says, well, actually, no, that's a bill and it is final, because that's what the law says. You need permission to withdraw it if you want to charge something else in respect of the same subject matter. So I don't think it is quite the same, but they're obviously, as I say, they're obviously questions which are very close to giving rise to a circle. Anyway, but that's in response to my Lord Justice Nugee. That's what we say self-contained means. It's self-contained in the sense it is final for its subject matter. So as I say, a BD, and it's the passage from Cordery, which my Lord Justice Lewison referred to a few moments ago. We have that quoted in extenso from page 90. It's the Cordery from 1999, and it's really the passage at the top of page 91. They're called statute bills because they comply with all the requirements of the Solicitors Act, which I've already sought to show you are very few, and the result of all the consequences which flow from such compliance. The solicitor can enforce payment by suing the client. The client can obtain an order for taxation, and the various time limits relating to the client's right to tax run from the date of delivery. Although they're interim bills, they're also final bills in respect of the work covered by them. That's the principle. And then there's this, which obviously can be used against me in a CFA case. There can be no subsequent adjustment in the light of the outcome of the business. They are complete self-contained bills of cost to date. And then there's this statement, which I have already suggested was probably wrong come 1999. Interim statute bills are rare. So far as the point that's made about finality in that passage from Cordery, and obviously everything that's said in this case has to be read in light of Boudier, where finality is much more central. But the question isn't whether we say it's not whether the bill is final in absolute terms, but whether it's final in respect of the things which have been billed. And that's what we say Boudier throws light on, which I'll come to next. There's obviously no consideration in the extract from Cordery of finality in the context of CFAs, still less discounted CFAs. Now, that's not something which could have arisen in a BD, because the facts of the case was that the solicitor was instructed in 1994, which was before any CFA was legal. And so far as discounted CFAs are concerned, those don't even begin to appear in the authorities until about 2008, so long after this passage in Cordery. The passage in Cordery about you can't adjust in the light of outcome, that is not something for which any authority is cited, or for which there appears at that stage to have been any authority. Hardly surprising given that CFAs had only just been made lawful. It is just possible that what they're referring to is the now almost forgotten practice, and it's again an example of just how even in some of the cases we're just dealing with a vanished world of the way in which solicitors did business. Because the court may remember that back then it wasn't unusual for the solicitors when a case was over to apply an uplift for care and conduct. And if a case had turned out to be very difficult and complicated and involved extra responsibility, a solicitor would contend for a much greater care and conduct uplift than the sort of traditional 75% or whatever it might have been. And so it may be that what Cordery is talking about is if you put in an interim bill that's put in your care and conduct a percentage at one amount, you can't at the end of the case then revise that to claim a bigger care and conduct uplift because of the particular shape the litigation took. I appreciate it's worth the speculation, but for my part I strongly suspect that is what the author must have been alluding to, simply because outcome related litigation retainers had only just been made legal when this case was decided. But the key point here is whatever Cordery means, it is just a statement in a textbook, not supported by authority. I mean, since I was myself at one point the editor of Cordery, one only has to state, an editor of Cordery, one only has to state that to see the potential fallibility of textbook writers. It is there, but in my submission that there can't be any sensible proposition that it decides how discounted CFAs are to be treated. And the rest of the BD we'll skip over because it's really about acquiescence. So really, I think that probably does take us to the Boudia case, the last of this court's quartet of decisions. And this is a case where finality is much more closely considered. And so the court has that in tab 15. I know that my Lord Justice Coulson was a party to the judgment, but the reason judgment is given by Lord Justice Nugee. In essence, the conundrum before the court is stated at paragraph 3, which is at page 212. So Mr. Slade's terms, which are the indented passage at 212, paragraph 3. Bills are rendered monthly in arrears. Our bills are detailed bills and are final in respect of the period to which they relate, save that disbursements, which is then glossed, are normally billed separately and later than the bill for our fees. Please do not assume, therefore, from bill for our fees, which does not refer to any disbursements, that no disbursements were incurred. The more usual situation is that disbursements will have been incurred and will be billed separately. And that is held by the Costs Judge and Mrs. Justice Slade to be fatal to the bills as interim statute bills. They're just requests of payments on account because they were not final for the period to which they relate.
Do you quarrel with what Lord Justice Newey says in paragraph 1, just by letter C, the third sentence? Whereas solicitors have delivered such a bill, i.e. a statutory bill, he can sue on it, but he cannot subsequently charge more for the work in question. Do you quarrel with that?
Well, I would quarrel. The answer is I wouldn't quarrel for it if one agrees with our submission that a subsequent outcome-related payment is not a charge in respect of the same work.
Yeah.
But if we are wrong about that, then I would respectfully quarrel with it, simply to say that the court is confronting, in this case, what in forensic, what in terms of decisions of this court is a new form of retainer, only made lawful in the last 25 years or so, and principles which have been stated in cases where there was no need for nuance because outcome related payment was then forbidden, can't be treated as having ossified into statutes. in cases which now have to confront this new form of retainer where you do have outcome related payment, in circumstances where the controlling statute itself doesn't include anything which would compel the court to conclude that that this form of payment arrangement simply cannot lead to an interim statutory bill, because there's nothing in the Solicitors Act which leads to that conclusion, and we would say that it's unnecessary. This is essentially judge-made law, which phrases that fell from very experienced judges in circumstances which were completely apt for the decisions that were in front of those judges. But this is a different situation, and as we'll see, in essence, that's what Lord Justice Nugee comes on to say about Barry and Rosen, which is a case relied on by the Costs Judge, which puts great emphasis on the need for finality. And the Lord Justice says, I'll come to it momentarily, but they just weren't considering cases on facts such as this. So if I can perhaps take it up at paragraph 28, which is at page 219. So Barry and Rosen is cited by the Lord Justice, Mr. Justice Spencer, and Mr. Justice Spencer, I think, cites without attribution the passage in Cordery. So that's the indented paragraph, no subsequent adjustment in light of the outcome of the business, complete self-contained bills of costs to date. And then there's a reference back to Davidson's and another previous case. And then one gets to paragraph 31. And I do, for my argument, I put quite a lot of emphasis on paragraph 31. Mrs. Justice Slade considered that application of the Barry principle leads to a requirement that to constitute a statute bill, it must contain all costs relating to a defined period. To my mind, however, that's to attribute to the words complete self-contained bills of costs a significance that they do not have. Barry and Rosen was not concerned with whether a statute bill had to extend to both profit costs and disbursements. And no such issue arose either there or in Davidson's or in the Adams case. The point being made in Davidson's, echoes of which can be found in the later authorities, was essentially that for a bill to be treated as a statute bill, it must be apparent that it is not merely seeking a payment on account, but is intended to be complete and final as regards its subject matter. And that whole sentence is one that I would metaphorically underline. The cases do not appear to me to assist with whether a statute bill has to include everything, profit costs and disbursements, attributable to the period covered by the bill. And then in the next section, the Lord Justice, under the heading of practicality and policy, refers to some of the practical objections to the approach taken in the lower courts, which he develops at paragraph 33. The difficulty in raising a statutory bill until disbursements have been invoiced by third-party payment suppliers, for example. And then at 34, and again, we would emphasise this as it were the court's lodestar. If one does need to decide a point that hasn't been decided at this level before, His Lordship goes back to the 1974 Act. The 1974 Act nowhere states that a statute bill must encompass both profit costs and disbursements, and I can see no justification for such a rule in the case law either. And he cites Ralph Hume, Gary and Gwilym. I don't think I need to read that. But if I overleap it then to marginal H, I would not wish to exclude the possibility of a bill restricted to either profit costs or disbursements failing this test on the particular facts. The test in question being whether or not the bill was something which the client would be in a position to have assessed. But that, however, would be the exception rather than the rule. I do not think it can be inferred that a statute bill must always or even usually include both profit costs and disbursements. Separate billing for profit costs and disbursements is common with modern digital billing, and I do not accept that it need give rise to problems. And then there's a citation of another decision from this court, so perhaps I should have said a quintet, which had been overlooked in the lower courts, which is a case called Erin and Acoy, where counsel's fees had been omitted from the bill because the client was disputing them. A district judge took the view that counsel's fees could not be allowed in a second bill because they had not been included in the first bill. But the Court of Appeal disagreed, and Lord Justice Hobhouse says if the matter is something which cannot be included in the first bill, then the solicitor cannot be criticised for omitting it from the first bill. Indeed, it would be wrong for him to include it. If one is to draw the conclusion that he should therefore be thereafter totally debarred from recovering what would otherwise be a perfectly proper fee, for a disbursement, that is an unacceptable and unreasonable conclusion which is not necessitated by the premise on which one is proceeding. But in any event, this is not a case where the paying party, the client, was in any way deceived. The first bill made it clear that council's fees were not being included, and the covering letter adequately reminded her of the reason why it was so she was not deceived, she was not led astray in any way. There is no general principle which precludes the solicitor from then including the relevant item in a later bill when it's proper for them to do so. And there's a submission that that's a decision on its own unusual facts. But the Lord Justice rejects that, saying it is inconsistent with the general principle that profit costs and disbursements cannot be billed separately. In all the circumstances, I take a different view from the lower courts. So what I draw from that is I do say that supports my proposition that one can't look at references to self-containment and finality as if they were words of a statute. You have to look at the actual problem the court is seized with in a given case. And as I know I've now said it more than once, none of the previous cases involve a discounted CFA. The concern about the court is whether or not the client is in a position, if it be an interim statute bill, to get it assessed and to take an informed judgment on that. And that's what you get from the citation of Rolfe, Hume, Gary and Gwilym at paragraph 34, which I rather leapt over, but perhaps I shouldn't have. Because what is being asked in that case is does the bill contain sufficient material that that the client can have a meaningful assessment, and then that takes.
Can I ask you about that?
Yes.
Take this case. Your discounted fees are 40% of the
35. The 65% is payable in any event. So the discount is 35%.
65%. Yes. Can the client have a meaningful assessment of a 65% bill?
Yes.
I mean, because the test on assessment is it a reasonable charge for the work that's been done, isn't it?
No, it's a question of have the fees been reasonably incurred, and are they reasonable in amount? So you can obviously say, well, have they been reasonably incurred? Should you have done the work?
But when it comes to the quantum, you'll be looking at 65% of your normal charges and saying, is 65% a reasonable amount for the work?
Well, I mean, what would happen in a time-based assessment like this is the court. I mean, the reality is in a case like this, the dispute on assessment is usually should the work have been done at all? Did it take too long? It's very, very difficult between solicitor and client to challenge an hourly rate which has been agreed. And outside of a consumer context, which obviously this emphatically isn't, one's dealing with an ultra high net worth individual who took, I think, 4 or 5 years to negotiate these terms of retainer with a battery of his own legal advisors. He's not going to be able to challenge the hourly rates. But I appreciate that doesn't help me with the point of principle that your lordship's putting to me, or doesn't necessarily help me. But I mean, in the real world, what an assessment between solicitor and client is going to be concerned about is should you have done the work at all, and if so, did it take you too long? And yes, of course, you can do that with the 65% bill. And you can even say, well, the hourly rate is too high because because you can't really challenge the 65% because I mean the amount of discount which the solicitor gives the client is a pure matter of negotiation between them, and don't immediately see any circumstances which a client could say you should have given me a bigger discount. The client might say that because the discount was that size at a later stage, the reward you get for that is too great. So you might challenge the reward later, saying that reward's just too high. You weren't taking much risk because you got 65% anyway. But you're not going to be able to, as a client, challenge the discount itself. That's a pure matter of negotiation. So the only thing you could say is that the hourly rate is too high because I shouldn't be paying 65% of £1,000 an hour because I didn't realise this at the time, but £1,000 an hour is completely aberrant in the London market. It ought to be 65% of £700 an hour. So you could certainly, in my respectful submission, have a meaningful assessment where and that is the form that it would take.
Is that right? Suppose the cost judge thinks that £700 an hour is reasonable, and you've in fact been charged £650 an hour. Your submission, what you've just said is you can say, I shouldn't be paying £650 an hour, I should be paying 65% of £700. But it's not obvious to me that that's what would happen on assessment, because the solicitor would say, a reasonable fee is £700, you're only actually being charged £650.
No, I don't. That isn't what would happen on an assessment because you obviously you would have to examine whether or not as I say, it would be extremely difficult because there's a contractual agreement to pay whatever the hourly rate may be. But you can obviously say that hourly rate is unreasonable as between you and me because the going rate in London is £650 an hour. I think your lordship puts me. So I shouldn't be charged £700 an hour, and so I shouldn't be being charged 65% of 700. I should be charged 65% of 650. I simply and I can't see there would be the remotest difficulty in that in a detailed assessment. And in fact, it's not a point that I think really is delved into below, but it's long been completely routine for there to be assessments whereby, for example, the solicitor's base charges might not be challenged at all unless just an assessment of the success fee and so on. It's perfectly possible to have an assessment which doesn't relate to the entirety of a solicitor's gamut of charges, but just, for example, well, I agree the basic fees, but the success fee shouldn't have been 100% because this was a rear-end shunt recorded on CCTV. The success fee, the solicitor took no risk at all, given even if the defendant wasn't insured, there's the MIB, so there should be either no success fee at all, it should be 5%, something of that sort. You can certainly have sort of localised disputes around.
I thought your submission in your written skeleton was that because the client hadn't challenged the initial invoice, he couldn't challenge the quantum when it came to the success-based uplift, because that's just a mathematical application of the same figures.
Yes, that's not inconsistent with all I've just said.
Well, no, I think it is, isn't it? I thought you just said that you could challenge.
Well, yeah, because that's the mathematical uplift.
Oh, I see. So, because I don't challenge a bill when it's first delivered, when I get another bill years later, I can't challenge that either.
Well, I'll make 2 points about that. The first point is I can be wrong about that and still win this appeal because that goes to the scope of the assessment if I'm right that the second bill is assessed separately. And it may be that I'm wrong as in my primary case as to what the scope of the second assessment would be. Maybe when you bill the 35% difference, at that stage a cost judge would be entitled to say, well, I can't challenge what you paid under the first. I can't interfere with what was paid under the first bill because that's done and dusted. It's been paid, and we're out of time for an assessment. But I can assess the difference between the two bills, which results from the second bill, and I can look at everything. So that would be our secondary case. But our primary case would be that in a case like this, whereas I've said in the real world, if you want the real bone of contention is has the solicitor spent too long doing things or done things which they shouldn't have done? And if you want to say that is something on my primary case you should say when you get the first bill, because that is the time-based bill. The second bill on this hypothesis is just a mathematical uplift using a formula that the client has agreed and negotiated. And yes, they can challenge it if they want to. They probably wouldn't get very far. But yes, of course, the client, in the example I just gave, the client could say, well, actually, on reflection, you bamboozled me into agreeing a mathematical uplift, which was completely out of proportion to the risk you were taking. On the authorities, on the English authorities, a success fee is meant to at least have some connection to risk. And I'm going to ask the judge to diminish your success fee because you're being remunerated for a risk you simply didn't face. So there isn't any difficulty with my first proposition, but if I'm wrong about that, having a more expansive assessment does not disprove my primary proposition, however, that in those circumstances, the costs which have been paid under the original bill, that is a closed book. Because the time that it's been paid, there was no application to assess it, and the time limit has expired.
Now, if we're going to hear all four of your grounds of appeal, we need to keep an eye on the time.
I do appreciate that. I hope that I obviously hope that I have been keeping up a relatively decent pace. But can I therefore just conclude then on ground one and to some extent cover it over. What we do say with respect is therefore this proposition about finality and self-containment is an objection. is to take an overly literal or dogmatic approach to statements in these previous authorities that don't go to the conundrum with which we are seized. Cases like Barry and Rosen simply aren't discussing this. There's no finality difficulty here, we say, when finality is approached in the way it's approached in Boudia, as the bill for discounted charges is final for those charges. In the language of Boudia, that bill is final as regards its subject matter being the discounted charges. So there simply isn't a finality difficulty. And in respect of what I'll call the conditional charges, if the condition later eventuates, that would trigger a new and separate charge, albeit it may be calculated as a mathematical uplift on old charges, but it is a new and different charge, which is incurred when the condition is triggered. And in no sense does putting in a bill for that undermine the finality of the prior bill for the undiscounted charges. And that is fortified when one looks at, and I know this is something that I've just been debating with my Lord Justice Nugee, when one looks also about how Lord Justice Nugee sense checks his conclusion, which is to say, well, could you have a fair assessment? And he quotes that really being the test in Wolf and Gwilym. Well, I think more precisely the test is, could you get the necessary advice to enable you to decide whether or not to seek an assessment? That's the actual test in the Gwilym case. And the Lord Justice says, well, yes, of course you could. Now, obviously, I'm not dealing with a dichotomy between a bill for profit costs on the one hand and a bill for disbursements. I'm dealing with a different dichotomy, a bill for unconditional fees or discounted fees, and a bill for later conditional fees. But on the approach I'm commending, would the client be deprived of the opportunity to have a meaningful assessment or get advice on assessment of the initial bill for the unconditional discounted charges? And in my respectful submission, is the answer to that is simply no, of course he wouldn't. There's no prejudice to the client at all. They can challenge that bill if they want to. If they don't, then that payment for the solicitor and client alike becomes a certain payment that's, if you'll forgive the cliche, water under the bridge. Doesn't stop the client challenging the conditional fees if in due course the eventuality is triggered by which those new fees are earned. And I do say that is fortified when one remembers what this principle of finality is actually directed at. And I think this is the passage that I referred to earlier in Coulson, whether the court wants to turn it up or not, but just to make good what I said about it, it's really a sort of anti-avoidance concern. It's tab 5, page 54. That's three lines, it's the first substantive paragraph, 3 lines down. That rule was laid down to prevent any attempt being made by solicitors to impose on clients who did not know what the proper charges were by sending in a bill which would not stand taxation, and then when taxation was insisted upon or threatened, sending in another bill which they knew could stand taxation. The rule has been carried so far that even where objections have been made to particular items of the bill delivered, and the solicitors have, with the assent of the client, taken back the bill for the purposes of reconsideration and have struck out certain items, the court has held that the bill to be taxed must be the bill as it was originally sent in and not the bill as amended, and there's a citation of in re Heather. So it is again, you tie in with the fact there's an anti-avoidance concern. You also tie in with the fact that, as Reed Thompson also...
I'm sure it's my fault.
No.
I don't understand that point.
Okay.
An
Forgive me.
anti-avoidance concern?
Yes. The principle, what I'm saying is the origins of this principle of finality, this judge-made principle, because as we've seen, it's not in the Act, is a concern that if solicitors were allowed to alter bills once they had delivered them, that would be that would enable an avoidance of the rigours of taxation, as it was then called, because by the solicitor just being able to withdraw an excessive bill and replace it with a more modest bill, and that's what. And what I'm saying is that mischief is in the principle is developed in order to protect against. It's not a mischief which is triggered. And if you can do what I submit you can do, which is to have a discounted CFA arrangement, whereby you can bill on an interim basis, on an interim statutory basis, for your discounted charges which are unconditional. And then subsequently, if there is ever a trigger, a bill for the conditional balance as a separate and also self-contained event.
But that wasn't the problem in any of the cases which talk about finality and self-contained bills.
No, but what I'm saying is the origin of the principle of finality, which is a judge-made rule, as we see it.
We're looking at the 1974 Act by reference to what the origins in Victorian statute.
Well, firstly, yes, because it's simply a reenactment. Well,
I'm sorry, I'm going to hang you with that petard
Yes,
on
I
a
know.
number of occasions.
Yes.
Costs is such an Alice in Wonderland world to the ordinary person that this is the sort of debate you get into, I think.
yes,
I mean,
well,
that might have been the reason, but now the reason for finality is the common sense one, that it can't be revisited. It's done and dusted. There it is. The
Right.
certainty that you referred to.
Yeah.
I mean, that's the reason for it.
well, I mean, the first thing I would say is that I obviously am very happy for your lordship to use my own rhetoric as a sort of whipping block, poetic justice, some might say. But in my respectful submission, the Alice in Wonderland perspective here is that on the other side of the court. Firstly, to say these aren't bills of costs, and secondly, to say there is some sort of great conceptual difficulty with having a CFA which has an unconditional and a conditional element, and being able to bill in accordance with the statute for the unconditional element. So that is done and dusted and certain and can't be reopened years in arrears. I do accept that somewhere in this court there is a portal into Wonderland or through the looking glass, but my submission is it's on that side of the court, not this one. So
You said a little earlier, you said, so I say it's final, that's to say the bills here, final in respect of the things which have been billed.
well, by which I mean in this context is final in respect of the discounted charges.
I mean, the difficulty with final in respect of the things which have been billed is that, say, it missed out a partner who'd spent a week working on it that had been missed out of the bill, then on your formulation, that would be capable of being billed in a different bill because it hadn't been billed first time round, and the bill was final, but only final in relation to the bill without that additional fee.
Well, I mean, that was obviously a probably a crude and imprecise paraphrase by me of what I'm really saying is the principle which is articulated by Lord Justice Nugee in the Boudia 1 case, which is that the bill has to be final in relation to its subject matter. So in respect of the example which your lordship has just put to me, obviously the time spent by the partner would be part of the subject matter because it would be part of the bill for the discounted fees. And so if that had been omitted, that is part of the discounted fees, then you have to come back. But insofar as in due course, Mr. Partner here is Mr. Huntley. Mr. Huntley may be able to charge the other 35% of his fees as part of the incentive arrangement and a success fee of up to 35% on top of that. I mean, that is not billing for the same in our submission. It is not billing for the same work. That is or for the same subject matter. It's not billing for the same subject matter. It is a separately provided for new liability, which is triggered by a particular outcome in the litigation, which by definition can only occur in arrears, and you are not in any way altering or amending the original bill for the discounted charges by putting in a new bill for the new liability for the undiscounted charges. It is a new liability. And it is not offensive to the finality of the original bill, therefore to bill it, and that's what it reduces to.
The undiscounted charges are the rate for the work that was done and was covered by the first bill.
Yes.
So I don't see why you're not raising an additional charge for the same subject matter.
Well, so far as that's concerned, I mean, really, we put the point in a number of ways in our skeleton. As we say, if you have a retainer under, I think we put it alphabetically, if you have a retainer under which liability A is payable unconditionally and liability is payable conditionally, then billing for unconditional liability A doesn't cease to be a final bill for unconditional liability A. If in due course conditional liability B eventuates, it is simply a new obligation, which is not therefore the same subject matter as the initial bill. Yes, it may be related back. It wouldn't. I suppose it would have to be. You might set up this sort of arrangement so you got paid, 65% of your normal fees in any event, and if you achieved a defined success, you then got paid, let's say, a sort of lump sum award of £1 million, something like that. That obviously would not relate back to the original work, and presumably one would simply say, oh well, that's just a completely separate reward structure, which does not clearly, on no view, involves reopening the bill for the time-based bill. What it's saying is that somehow all changes because the reward in question isn't a completely distinct award, but operates as a mathematical uplift on a prior payment which was time-based.
If the client were to say, well, what are you charging me for? The answer surely would be, we're now charging you the undiscounted rates for the work we did 12 years ago, whatever it is.
Well, that's obviously right, but where I'm simply not, as it were, travelling with your lordship, is the proposition that therefore means that the original bill was not final. It was final for the discounted charges. What has arisen subsequently is something separate and different, albeit is a function of the discounted charges, but it is still a new liability which does not offend any principle of finality. If one, and I do continue to reinforce that, notwithstanding the intervention from my Lord Justice Coulson, by saying that is reinforced by when you look at what the mischief this is actually directed at. And actually, having put to me that I was committing the desert island fallacy impeached by Lord Sumption in going back to Lee Thompson, the example which my Lord then put to me about forgetting to charge for an entire work stream and and trying ex post facto to insert it. To insert it into bill. That is actually the very sort of thing which the old cases are saying you can't be you can't do. You can't just without the court's permission correct errors, go back and fix oversights, things of that sort. You have to have the court's permission. But what we are dealing with is a position which is infinitely closer to that which Lord Justice Hobhouse is addressing. In the case which whose summary I read to you in the body of Boudier just now, if the matter is something which cannot be included in the first bill, then the solicitor cannot be criticised for omitting it from the first bill. Now, obviously, Lord Justice Hobhouse is talking about something completely different. He's talking about a situation where they couldn't include counsel's fees because at the point in time that the bill was drawn, counsel's fees were subject to a dispute. But in my respectful submission, with necessary modifications, the principle is exactly the same. If you can't include something in the original bill because it hasn't then been earned, you're not reopening the first bill if, because of a subsequent development in the case, it is earned and you charge for the new fee that you've just earned. In no sense does that disrupt the finality of the first bill, or still less offend any of the mischiefs to which the issue is directed, which is having second bites of the cherry, if I can use another cliche.
Is it as simple as this? Your submission is that the same subject matter means the undiscounted, the discounted yes. charges for the work that's been done.
Yes.
Whereas the case you're facing is that the same subject matter means the work that was done. Because you are being paid twice for the same work if you get the undiscounted charges.
I suppose it does essentially boil down to that, and I say that simply occasions no difficulty because that's an extremely useful way of organising the remuneration of solicitors, which is extremely popular in the market, which is good for clients, and it simply causes no disruption to the statutory scheme for detailed assessment. In saying yes, just like the statute allows you to put in interim bills for a particular period of work in the days before you did have payment by outcome. So there's nothing in the statute that stops you putting in a bill for a particular unconditional element of your work, and that's the final bill for that work, which if you want to challenge, you have to challenge it within a year, and all the other rules nothing onerous to the client there. And then saying, and then under this new form of retainer, not lawful in 1974, not lawful in 1893, whenever it might be, there is then a subsequent second entitlement, contractual entitlement, because of an outcome-related payment. In my respectful submission, there is simply no difficulty in accommodating that within the statutory structure, unless you start reading these cases referring to the need for self-containment and such like, which were all decided in a completely different context with different concerns, as if they had ossified into additional requirements in the statute itself, and that emphatically isn't the position.
Yeah.
Can I just turn behind me for a
Yes, of
moment?
course.
Yes, I'm just reminded, I'm sure the court hasn't lost sight of it. I mean, we do say in our skeleton that I know my Lord Justice Nugee has just put to me, but it is being paid twice for the same work. Obviously, I can understand why your Lordship put that to me, because it is a mathematical function of the previous work. But we would submit as a reinforcement to our submissions another sort of perfectly economical, a perfectly legitimate categorization is how we categorize it in our skeleton, which is to say, well, no, I mean, it may be calculated with reference to past work, but it is actually a reward for the risk that you have taken in circumstances where you have been vindicated in taking that risk by subsequent events. So it isn't, although it is a function of the past work, it is in fact a charge for a different thing. That's how we view it in our skeleton. But really, my whole
that you took was doing the work and possibly not being paid the 100% fee.
yes.
So the risk and the work are coterminous to that extent, aren't they?
Yes,
That's the risk. You do the work thinking, well, I'm going to do this work at a discount in the hope that at some point in the future, because of the contingencies working out, you get paid the full rate.
Yes, but with respect, I agree that that's a fair way of putting it. But also, I mean, perhaps more realistically, this case, I suspect, is not going to turn on the precise label that one attaches to the uplift payment, if I can call it that, or you know, the nuances of how an economist might classify that as compared to how a lawyer might classify
Well,
that.
the skeleton spends some time on that, so
It does.
it's slightly disheartening to hear that that might not be very.
Well, I'm not saying that.
Characterisation does seem to be, on a reading of the skeletons, to be quite important.
Well, I'm not saying it is unimportant. I'm just saying it might be, however, that even you can. What I suppose I'm trying to say is you can reject out of hand what we say about categorisation, and still, in my respectful submission, come to the view there is just nothing in the Solicitors Act that compels the conclusion that that a second bill for an contractual entitlement which only accrued after the first bill, and which in no sense requires the first bill to be reopened or reconsidered, or for you to charge a second time for the subject matter of the first bill, viz. The discounted charges. There simply is just no difficulty in accommodating that within the existing scheme for detailed assessment as between solicitor and client, whatever label you hang on the economic nature of the second charge. I certainly do maintain the argument in our skeleton that it is actually qualitatively different, albeit it relates back. But whether or not you agree with me about that, in my respectful submission, the appeal should still be allowed. My Lord, those are my submissions on the first ground.
The ground one. Yes, thank you. Yes, Mr. Mallieu.
My Lord, thank you. Before turning to the substance of my submissions in response on ground one, if I may, just whilst they're fresh in our minds, pick up on a couple of the final points Mr. Williams made, which will hopefully save me coming back to them. The fundamental problem with the appellant's appeal here became, in my respectful submission, immediately apparent when Mr. Williams was taxed, if I can be forgiven for using that word, on the question of what the 35% represented, whether this was billing for the same work or whether this was something different. And despite what's said in the retainer documents in this case, which of course you've not actually been taken to yet, but will come to, which in my respectful submission, make it absolutely plain that there is a standard fee for this work, which is the 100%. and then there is a discounted amount which is asked for as the matter is going along, and makes absolutely plain, therefore, that at the very least, the 65 plus the 35 is a charge for the work done, and we say the uplift can only be a further charge. What we would ordinarily describe as a success fee can only be a further charge for that same work. In order to try and persuade this court on this appeal, Mr. Williams is driven to the point of saying no, the 35% and the uplift on top of that are in fact a completely separate reward. They're not a charge for the same work at all, and indeed is driven further and is driven to the point of saying both those parts are a reward for the risk being taken. And we can immediately explode the fallacy of that, because if we ask the question, essentially the question that, as I understand it, Lord Justice Coulson was raising a few moments ago, what is the risk being taken? And if we just focus for a moment on the 35% discounted fee, that's not a reward for the risk being taken, that is the risk that's being taken. The risk that's being taken is the solicitor is essentially saying, we would ordinarily charge you 100%. We will take a risk, which is that if you don't achieve a certain outcome, we will only charge you 65%. So the risk is not getting the 100%. The reward is if we do succeed, we'll have another 35% on top of the 100%. So the reward is the 35% bonus, but the difference between the 65 and the 100% is not the reward, it's the risk. And so that immediately becomes apparent that Mr. Williams' taxonomy is flawed here, because he's forced to try and describe both of those elements as something they're not, in order to try and avoid the consequence, we say, of what the authorities say in relation to statute billing. And I'll come to that in just a moment. The second point, just to make briefly at the outset, if I may, is just to sound a little warning note, and it may be that we don't need to spend much time on it at all, about the Thompson case that you were taken to. I'm not going to invite you to turn it up unless it will assist when I make the short point, in which case, of course, we can do. The Thompson case is dealing with a question of the circumstances in which a solicitor is able to reserve to themselves the right to withdraw or vary a bill of costs. And in brief summary, what the Court of Appeal concludes is that if the solicitor expressly reserves to themselves that right, and it's fair for them to do so, then they may be able to do that. But that is not dealing with what the appellant is contending for here. The appellant is not contending here that it has a contractual right, if these are interim statute bills, in due course to vary or amend them to include the additional fees. The appellant is contending they've got a right to render a completely separate but additional bill on top of the bills they've already rendered. And the reason, of course, they're not contending for the former is because it's not the outcome they want. Because if what they were saying was actually we've reserved ourselves a contractual right to vary these bills, they're statute bills, but we've reserved a right to vary them as and when we want to render additional charge, the obvious consequence for that would be the varied bill would give my client a right to an assessment of that entire bill as at the date of the variation. And therefore, once we know what the final charges are we face, my client would have a complete right to assessment of all of the charges. Now that, of course, is not what Signature want. So they're not, in fact, in Thompson territory, despite the fact they rely on it. They're in very different and much starker territory, which is saying, no, we've actually rendered a complete bill for what we say are plainly just part of the potential charges for the work done. And we want that to be final. And then in due course, we want the ability to render a further bill for more charges for the same work done. And that, we say, is a much starker proposition and is one which is not supported by and not permitted by the authorities on the proper question of what is meant by a statutory bill. And there are two short propositions that we say dispose of ground one. And to be clear, we say in terms, if we dispose of ground one, we dispose of this appeal. And I'll explain that in just a moment when I've set out the two propositions, if I may. The first proposition is that for a bill, a solicitor's bill, to be a statutory bill within the meaning of the Act in section 70, it must be a complete and final bill for the solicitor's charges for the work done in the period that it covers. So that's the principle, and then the second...
Where does that principle come from?
Well, we say it comes from the authorities, and I'll take your lordship to the authorities in a short moment.
Well, and what are they doing, these authorities? They're interpreting the phrase "a bill of costs," are they?
That is what they're doing. They're interpreting what is required in order for a bill of costs to be a bill of costs within the meaning of section 70 of the Act.
So it's all about the interpretation of that phrase, "a bill of costs."
My lord, it is, yes. Yeah. And so we say when we come to the authorities, we'll see from the authorities that a line is drawn. That there's been, as Mr. Williams has taken you to, there have been various cases dealing with what's required for a bill of costs. So, for example, what's required by way of a narrative and what's required by way of detail. All of these cases which are, to use Mr. Williams' expression, glosses on the plain words in the statute. But they're now established in case law as to those being fundamental requirements, and without them, the bill would never be a statutory bill subject to assessment. And there is an additional one, we say, which is that the bill has to be final, and that's clear. And the question we're grappling with is what's meant by final. And we say the authorities work on the premise that yes, you can have a statutory bill for solicitors' charges and a separate statutory bill for disbursements, and we'll see why when we come to the statute and the cases why that is. But when it comes to the solicitor's charges for the work, the whole idea is, in order for a bill to be a bill capable of assessment, therefore a bill within section 70, it has to be complete and final for the charges for the period that it covers. So that's the proposition of law that we advance, which we say is established in the authorities. Our second proposition really is a proposition of fact, which is that when we look at the facts of this case, and it's the point I've already introduced in responding initially to the final parts of Mr. Williams' submission, when we look at the facts of this case, there can be no real doubt, we say, that the additional charges, the conditional fees, as Mr. Williams describes them, the 35% discount and the 35% uplift and potentially a percentage of damages are themselves part of the solicitor's charges for the work done.
Does it follow that you can never deliver an interim statute bill in any case in which there is a CFA?
Oh, my lord, I think yes, that probably is the consequence. And of course, in most CFA cases, that would be the obvious and invariable consequence. If we take a simple CFA, of course, there is no liability until you...
If it's completely
It's a
conditional.
complete CFA.
Completely conditional. But we're told that it's now very common in commercial cases to have these discounted CFAs, so that this is standard practice.
Discounted CFAs are indeed common. They've been common, they're increasingly common, but they've been in use for 20 years or so, but they're increasingly common, have been over the last 10 years.
And it's a feature of them that there's a certain amount of the standard fee which is payable in any event, and the rest is payable only in the event of success. And then there is some usually success fee, uplift, extra bonus as a reward for the risk you take in not getting your 100%.
Lord, yes, broadly that's the inherent nature of a discounted CFA for the obvious reason it's a discounted, therefore it operates on that discounted basis, and solicitors generally speaking aren't willing to take that discounted risk unless there's a benefit to them in doing so, which is the success fee on success. So yes, they're in common practice. Where I would differ with Mr. Williams is the cri de coeur that this case is the game changer, where if this court dismisses this appeal, there's going to be a fundamental problem. Because what we say is, in fact, it's the appellant's case that's seeking to change what was generally understood to be the established principle, what an experienced cost judge, such as Costs Judge Leonard, understood to be the established principle, which is that yes, in those cases, yes, you can have essentially money on account, and yes, and I'll come to develop this in a moment, to take the point that was raised by the Lord Justice Nugee with Mr. Williams, yes, in those cases, that money can be used by the solicitor. But until you get to the end, the solicitor doesn't have finality in knowing that that money will always be theirs. They are at risk potentially of an assessment whereby they may end up in a position of having to pay something back if that assessment goes against them. So there's nothing to prevent them using the money in the interim. There's nothing to prevent them seeking the money on account.
It seems to me to be rather distracting to say that this is the client's money, in the sense that the client is the client's property.
Oh.
The process of assessment may require the solicitor to make a payment to the client for the bit that's being taxed off, for the reduction in the bill. But the money, I would have thought, when paid to the solicitor, is the solicitor's money. There may be a contingent liability of one kind or another to make some payment to the client, but in terms of a proprietary interest in the money, I would have thought it's the solicitor's money.
Lord, I absolutely and completely agree. And I'll take your lordship in a moment. We have copies of the solicitor's account rules here. So if I may, in fact, this may be an appropriate moment because it may take perhaps 5-10 minutes just to work through them, and we can do that in the build-up to the lunch and adjournment. I'm sure Mr. Williams indicated that he and Mr. MacDonald were considering them yesterday, so I'm sure he's familiar with them and able to address them. So copies are available, and we'll hand them up.
It's the basic position that money on client account is the client's money, and the solicitor is a fiduciary trustee of it, but money on office account is the solicitor's money.
My lord, yes, and what we'll see in a moment from the solicitor's account rules is that what's required for one to be transferred to the other is to tell the client that that's what you're going to do in a specific sum. And so these are the solicitor's account rules. I should say there is a consultation which was commenced by the SRA in 2023 to introduce some clarificatory amendments to these rules, which, as I understand it, is still ongoing. And I only mention it because there's one point in passing. I don't have a copy of the latest version of the consultation available, but if need be, we can get that to you. So these are the solicitor's account rules. And if we can just pick it up at Rule 2, you'll notice this has obviously come from the website. It's obvious, but the underlined terms in red have a definition. They're defined terms within the rules, so we can see which are defined terms and which aren't. So 2.1, client money is money held or received by you. And then if we just come down to D, in respect of your fees and any unpaid disbursements, if held or received prior to delivery of a bill for the same. So that was the point that Mr. Williams was referring to, suggesting, although I don't think this was any part of their written case, suggesting that the money remained client money until the bill was delivered. Just at 2.2 in passing, we can see that where it is client money, if it's in respect of disbursements, then it doesn't need to be held in a client account if you inform your client in advance of where and how the money will be held. So that's an exception for disbursements. And then if we come on, apologies, there's no pagination, but if we come on just a couple of pages to Rule 4, so the general principle at 4.1 is, of course, you keep client money separate from essentially the firm's money, authorised body's money. And then 4.3, where you are holding client money and some or all of that money will be used to pay your costs, A, you must give a bill of costs or other written notification of the costs incurred to the client or paying party. This must be done before you transfer any client money from a client account to make the payment. And little c, any payment must be for the specified sum identified in the bill of costs or other written notification of the costs incurred and covered by the amount held for the particular client. So in my respectful submission, it's quite clear from Rule 4 that what you have to do is simply give the client a written notification. We are holding this money for you. We intend to transfer this specified sum from client account to our account, and it moves from the position of being client money to solicitors' money that they can use as they wish, subject to the contingent risk that they carry, as they would have always carried in any classic case where retainers were entire retainers, which is if the client's given some money up front in advance and the firm chooses to use it, and at the very end the client comes along and has an assessment, then the solicitor might, not necessarily out of that money, it's not traced into that money in that sense, but might have to pay a sum back to the client, which represents in essence a part of the monies that they took from the client and used for their own purpose.
How does that work here? Because I've just noticed that on the invoices, the payment details ask for payment to be remitted to the client account. So it goes into the client account. And then
Yes.
Does it come out straight away, or how does it work?
Yes, I think Mr. Williams indicated in practical terms, there's no evidence, but he assumed that the money had been used and transferred out. But there's no actual evidence on it. But the bill would serve, whether it's a statute bill or just a bill, serves as the written notification. The money is initially paid into the client account, but because the client's had the written notification,
You
the
can
solicitor's
transfer it
entitled
across
to
at any
transfer the money across to their office account.
time. Yes, thank you.
The only wrinkle in relation to this that was raised by Mr. Williams was in relation to what is said under 2.1 D. So it's the second page, where it refers to client's money being money held ... received prior to delivery of a bill. So the suggestion from Mr. Williams was, despite what it says in terms at Rule 4, that in fact Rule 2 in some way means that no, the money remains client money unless and until an actual statutory bill is delivered. Now I just make 2 points in relation to that. The first point in my respectful submission is the specifics of Rule 4 in my respectful submission must take precedence to any
Wait a minute.
generality in
Is
Rule 2.
Client money is defined as including money received by the solicitor in respect of fees if held or received prior to delivery of a bill.
Yes.
So that's client money, and let's assume that bill here means a bill is a statute bill.
Yes.
Rule 4 then says where you're holding client money, i.e. money which was paid to you before you delivered a statute bill, you can transfer it if you notify the client.
My lord, that was going to be my secondary point, which is in any event, if it is deemed client money because it's being held prior to the delivery of a bill, then in any event, as client money, it can be used in accordance with Rule 4. The third point I was just going to make in passing is my understanding, but we'll obtain copies of this if it assists, is that part of the SRA consultation is to make a clarificatory amendment so that in the future 2.1D will read prior to delivery of a bill or written notification. So somebody seems to have spotted the slight wrinkle and suggested a clarificatory amendment. Now that's only a proposal. It may not go through, but it seems to me it's obviously a sensible amendment, just not because it's needed, but because it removes any confusion of the type that we've been dealing with. So just on that point, we say, and I'll move on from the SRA account rules unless there's anything further from the bench, but we say that in practical terms, the position here is very simple. You give the client, in this sort of case, a written notification that the firm requires payment of whatever the discounted element of the fees are, so that it can use it for its own purposes. The client pays the money, you can transfer the money, but the firm carries a residual risk that when the client ultimately knows what complete charge it faces for the work done, if the client seeks an assessment, and if the client is successful on the assessment, then the firm may have to dip into what is now its own pocket to pay some of that money back. And of course, the other point we would make in practical terms is if we think through the consequences, if there is a case where the solicitor is successful, so that the conditional fees become payable, and the client then says, well, now that I can see that I'm being charged £1,000 an hour for all of this work and that the total bill is X million pounds and 35% on top, it seems to me that's all a bit too much and I want to challenge that. If the client brings that challenge, in practical terms, in most cases, unless the solicitor's done something disastrously wrong, in most cases, the effect of that assessment is likely to be to reduce the total bill by 10, 20, 30%, whatever it may be. And so in practical terms, where you're likely to end up is that the solicitor will have taken 65% or whatever it is, will have transferred that for its own use, will then produce its final bill for its total charges at 135%, may be told by the cost judge, actually that's too much, you can only have 100%. And so we'll still actually never have to dip into the monies it's already taken to pay anything back, because it's only taken part of it. So it will still probably end up keeping those monies and maybe get a bit more besides, just won't get as much as it's asking for, if that makes some kind of sense. So as a matter of practice, we say this sort of creed occur that if this appeal is dismissed, this will be a disaster for solicitors who, for the best part of 20 years, have been working on discounted CFAs without the benefit of a decision from this court saying that their bills for the discounted element can be interim statute bills. It is simply misplaced. And of course, I do make the point, it's entirely unsupported by evidence. It's purely made as a submission. There's no trade body, none of the professional bodies are here saying, if this happens, this will be a disaster for us. It's purely a submission.
At some point, but up to you now, I'd like to hear what you say would happen if there was no success. When does the final bill get put in? Because on your case, there hasn't been a final bill yet. And what would the final bill show? The final bill of 0 or of X pounds, of which you've already paid X pounds?
My lord, yes, the reason that there isn't a final bill and can't be a final bill is because Signature have taken to themselves the ability to charge further fees for this work. So at the moment,
But
we
I
do
understand,
not know if this
I
is the
understand that,
final
but in
charge.
another case,
Yes.
you got a discounted CFA to run a piece of litigation, the litigation fails, you've paid your discounted amounts, there's never going to be any more payment. What does the solicitor do?
The solicitor then serves their final bill. They say to the client, the point has been arrived at where the contingency has now collapsed. We know what the outcome is. Here is now, therefore, our final bill. And that final bill may be simply repeating what's already been said. Indeed, it could probably be done in very short form, which is that I don't want to disappear down the road of issues like Chamberlain bills and things of that kind, but it could be done in very short form by the solicitor essentially saying, that bill on account that we sent you before, we're not charging you anymore. That is now our final bill.
And at that point,
And
you say you can then have that
with the
taxed.
effective date of that notification.
Yes.
And at that point, the client can then say, well, again, I now know what the total charge is for the work that has been done. And I can decide, am I happy with the 65% that I've paid? And therefore just say, fine, you keep that. Or is there some reason why I'm not happy even with the 65%? And therefore I want to, but it's only at that point, that's the key point. It's only at the point once the client is told by the solicitor, this is the total charge I'm ever going to make to you for the work that is done, that the solicitor is able, therefore, to have a bill which can be treated as a final statute bill, because it's only at that point the client is able to say, what am I being charged for this work done, and do I want to challenge that? So that, I mean, that really is it. I'm obviously, unless your lordships tell me not to, I'm going to develop the point, but that really, in a nutshell, is what we say is at the crux of this, and where we say the appellant goes wrong. It's the failure to appreciate, and the difficulty, the dancing around the houses we've done to try and avoid appreciating that what Signature are doing here is reserving to themselves the right to charge further charges for the same work done.
Is there or might there be a difference between an agreement which provides for the solicitor to be able to charge the 100% fee, which is calculated by reference to the work that was already done for the 65% fee, on the one hand, and a pure success fee on the other? Because I think Mr. Williams accepts that if and when Signature put in a final statutory bill for the extra 35%, you can challenge that, which I find it difficult to see how you could challenge that without reopening the interim bill. And if you say that they spent too long on doing some piece of work or whatever it was, it would be the same. You'd have to go back to the interim bill. But if it was simply a success fee, which had nothing to do with looking at the work done, is there a conceptual difference between the two?
My lord, if I can just work through that, and I will answer the question directly, but if I can just work through the various parts of it. So as I understand Mr. Williams' primary case, it's that if these are interim statute bills, then when a bill is rendered, if we just stick with the 35% for now, even when a bill is rendered for the additional 35% on his primary case, we can't challenge any of the detail of the work that goes to make up that 35% charge. His secondary case is if that's wrong, yes, we can do that, but that still doesn't stop the original bills being final for the 65% charge for that work. And at that point, and perhaps it's something for Mr. Williams to further explain, I'm in the same difficulties your lordship are in as to seeing how in practice that is possible, because what you're really doing is dealing with the same time that's been spent doing the same matter, and what the question is of the reasonable charge for that being done. And that, of course, is what an assessment is of. An assessment isn't per se of the hours. The assessment is of the charge that is being made for the work that is done, whether it is reasonable.
Well, that leads to the question I asked Mr. Williams. Suppose you agree that the standard fee is £1,000 an hour, but you're only going to pay undiscounted 65% of it. So your initial payment is £650 an hour, and the costs judge ultimately decides that a reasonable fee is £700. Now, if you're just assessing the first invoice, take a case where the claim fails, so there's no uplift, and all you've got is the 600. All your charge at the end of the day is £650. Can you challenge that on the basis that I only agreed to pay 65% of a reasonable fee, so I should only be paying 65% of 700? Or is the answer, well, you're only paying 650, a reasonable fee would be 700, so you've got no complaint?
Well, look, that is part of the difficulty. In my respectful submission, the court on an assessment assesses the bill that's presented to it. And as Mr. Williams indicated, its job is to assess whether the charges are reasonably incurred, reasonable in amount, and ultimately what is a reasonable sum for the client to pay for the work done. Now, if the court is presented with a bill which is a letter of claim was drafted, and the fee for the letter of claim is 5 hours at £1,000, but in fact that's discounted, so it's only 5 hours at £650. The total fee for that letter of claim is therefore £3,250. My maths worked for once, which is unusual. So the total fee is £3,250, and that is the fee that is being claimed in the bill, and that is what the court is assessing. Now, the ultimate question for the court is £3,250 a reasonable fee for the drafting of the letter of claim? But the problem for my client is he may well say, well, actually, I can't really complain about paying £3,250 for that letter of claim. Therefore, I don't challenge that fee. So that fee is assessed. Mr. Williams' case then is, in due course, we can be charged an extra 35% plus the 35% uplift for that, which takes it back up to the £5,000 plus more besides. But at that point, we can't go back and say, well, actually, too much time was spent, it took too long. We've given up our chance of that. But at that stage, all we can say is, well, we know we contractually agreed to 35%, but we think that's been unreasonable, at which point the cost judge will say, well, actually, that was expressed, those were the terms of the contract. So I've got no option now but to allow this uplift. The other problem is, if Mr. Williams is right, when my client is deciding whether to seek an assessment of this interim bill for the charges, there are all sorts of tripwires out there, in particular section 70 subsection 9 of the Act, which is the 20% rule. So if my client seeks an assessment and if we don't get more than 20% off the bill, unless there are special circumstances, we pay the cost of the assessment. We have a bill of £1 million for work done for X period. My client looks at that bill, takes advice, and is told by a cost lawyer, well, actually, £1 million, you're probably not going to get very much off that. So my client has a choice. They seek an assessment of the £1 million, knowing that they're not going to get much off, but because they feel an obligation to try and tackle the time. And the cost judge looks at it and says, well, some of this time is excessive, but I'm actually ultimately assessing the charge, and the charge isn't unreasonable. So yes, Mr. Ivanishvili, you've made lots of wonderful points about Signature spending too long, but their charge is still reasonable. So I'm assessing the bill at £1 million. my client pays the costs. We then have a further bill delivered. We're told, well, actually, you've had your assessment of the time, and you've just got to pay the extra 35% on top. So what will happen is clients will not seek assessments because, and it's a point that we make in our skeleton argument, an unscrupulous solicitor would persuade clients at the start to always enter into a fee with some sort of discounted element, a modest discounted element, bill a modest discounted element as you go along, and it protects them against ever being challenged on their time. And that we say that can't be right. And in the 1 minute remaining, if I may come back to my Lord Justice Lewison's question about the success fee, is there a conceptual difference between the success fee and the profit cost? Just two very short points to make in relation to that. The first point we make is, even if there is, this appeal must fail, because if we are right that the extra 35% in and of itself is further charges for the work done, and a statutory bill must be full and final for the charges for the work done, then plainly these bills are not full and final for the charges for the work done. So even if there is a conceptual difference with a success fee, this appeal must fail. But is there a conceptual difference? We say in fact there isn't, because when we come to look at it, the real dividing line is between what we would call solicitors' charges and disbursements. And the success fee is part of the solicitor's charge for the work they've done. It's a different way of charging. But if you were to sit your client down and say, why are you paying at the end of this case, if it's successful, an extra 35% to your solicitor? They would say, yes, well, I'm paying it because they took something of a risk. But ultimately, what are you paying it for? You're paying it for the services the solicitor's rendered. It's a different form of payment for the services, but it is still payment for the services rendered. Therefore, it's a payment for charges for the work done. And I will, with the court's indulgence, just briefly develop that after the lunch and adjournment by reference to the statutory provisions that deal with conditional fee agreements, where we say it's capable of seeing that these are all part of the solicitor's charges for the work.
Right, 2 o'clock.
Court rise if able.